Oh. Oh my God. I'm sitting here thinking when you said you went deaf, I'm sitting here like thinking because I had my gain accidentally all the way up, and I'm like thinking that you meant because it was too loud, and then I like blew your eardrums. That is too funny. Okay. You could hear me now, right? You guys, do you think I could do the settings? Like I could make it like look one solid color. Should I just keep it, or you could make it blink and you could do different things. Should I just keep it moving like this? And should I keep it up? I usually have it down like this. What sounds better? Maybe I should put it up. You guys could see it better. But the only thing with it up is it's harder for me to see the screen. I need to like make my screen higher. How does it sound? Better like this? I wonder. Okay, so guys, new documents came out. A bunch came out. I know a couple came out. I know some stuff came out like yesterday, and I'm pretty sure these other ones, well, it says it's like 24 hours ago. So maybe yesterday, but I think there's some that came out a little bit earlier. So I think I'm going to read the newest stuff first. How many of you guys seen it? Like the transcripts for October 12th, October 19th are out. There's Mitch Westerman's affidavit, Rosie and Baldwin's affidavit for everything going on. You need like a light equalizer that shows when sound is going. It does. Look, when it's mute, it should be easy, right? But see, I have this thing right here, and I don't know. I thought for sure that was one of my favorite things. Cause I'm like, cause you know me mute, and I don't know. It's like, I'll for sure know, cause the light will be off. No, I don't. I'm not looking at it. Oh, thanks, Stephanie. Thank you. I feel like my hair, I think, looks better a few days after washing it. I used to like my whole life. I always washed it every day up until a couple years ago. I really, and I always, I heard the last few years, maybe last 10 years, oh, you don't have to wash your hair every day. And I'm like, yeah, I just cannot not. But the last, like, maybe like year or so, I started not washing it every day. Um, and like, I feel like when I get compliments, it's always on my hair, it's always after it's been a couple days that I haven't washed it. So it must look better. Like, it's less frizzy. You know when you're saying like I notice when I first wash it the first day for sure it's like really frizzy looking even when I straighten it because I straighten it this time. I don't always straighten it. But yeah, I feel like it yeah, sometimes looks better after a couple days. Hey Ashley, hey Brian, hey Melissa. Oh, you haven't seen any of it? Okay, cool. Okay, so hold on. I got a freaking dentist appointment tomorrow, guys. Gonna be a long one. It's a crown, but it's not a root canal. It's just a crown because my tooth chipped off. So it's gonna be like 2 hours because they make it. Oh, you can't see my hippie shirt. Hippie soul. Okay. I wish sometimes I could make it zoomed out more, but see the green screen the way it is, it cuts off at the edges if I zoom out anymore. Hey Hannibal, thank you. Honey Virgo. Alan, what up? Petty, what up? My roots and use conditioner on ends. Okay. No, I know you're not. You're not. And I always did because I just felt like you just like felt like, I don't know, like greasy or whatever. But finally, I'm just like, you know what? No, it's true because you need your natural oils. And it is. I mean, look, I feel like it is, right? I feel like my hair looks better, a couple days not washed. Anyway, all right. So let's get into it. I don't even know what order. I think I would just go in order from how they are, right? Ashley, what up? Cup of Curiosity podcast. Okay. Wash my finger. Okay, so. Let me grab this real quick. Okay, so yeah, I kind of don't like, well, I guess it's okay how they do it. You know how they'll keep like releasing that big document and then they'll just keep adding more stuff into it. So that's what they did again. We're going to start with, yeah, we'll just start from the beginning as far as I'm just going to read the parts that they just added, at least that I think they just added. I know some of them they just added, but like that I wasn't aware of, and so maybe some you might be like, wait, we already seen that, but I'm pretty sure most of the stuff that I have written down is stuff that just came out. Okay. Because they're slowly putting it out. All right, so the first thing, hold on, let me go over here. So we have I have page 4 to 7. So we have this document, the petition, and then we have the 246 page, then we have this, which is in the 246, but that makes it easy, and then the motion for the transcript. Okay, so we're gonna start here, page 4, or no, here. I wonder if we should start here. Okay. We're gonna start on page 4. I will read that, but I'm gonna read some of this other stuff first. Okay, page 4. Oh, whoa, I'm scrolled all the way down. Okay, so here's everything, and they released it in like 2 volumes. So this is volume 1, and then volume 2. Okay, so that's what's all in it. So we're gonna start with we have page 4 to 7. Why do I have page 4 and 7? Hold on a second. Just give me 1 second. I don't know why I put 4 to 7. Oh, that's the 41 page document. Okay, hold on 1 second. I forgot about that. Just bear with me here. Because there's another. Where did I do the 41 page one? Here. Okay. That's what I have. Okay, so this is volume 1. Yeah, that's why we're going to do this one first. I was like, wait, what the heck's going on? Okay, so page 4 and 7 on the 41 page document. So this is all, it's got the transcripts, all this stuff. Wait, do I have? Okay, I should. All right. So this is the transcripts, okay, from October 19th. Hey, Captain Cup of Curiosity. Hey, Laugh-A-Day, Ashley. Okay, so let me make this bigger. So we'll start here. I'll just check it off as we go. So page 4 to 7. Record of hearing. October 19th. Oh, I'm going to wait till this phone stops ringing. Sorry, guys. We still have a landline, and we barely ever get it. I'm like, Mom, why do we even have it? We don't use it. It just rings, and it's so annoying. Well, in case of emergency, Grandma, that's the only phone number that people know how to get a hold of her. I'm like, you could just give them your phone number. It's just like a waste. They never answer it. All right, so we have appearances for state of Indiana. We have Nicholas McClellan, James Luttrell, the Carroll County prosecutor, deputy prosecutor, and the Honorable Francis Gall. Jody Williams is the reporter. Hold on a second. Okay, so the proceedings. All right, we are on the record in the state of Indiana versus Richard Allen. Thank you for your patience, ladies and gentlemen. Oh wait, now this isn't the one I want to do because this is the what we saw. Hold on, sorry guys, don't be mad. I've skimmed through these. I didn't get a chance to like read all of everything I want to read because I didn't want to be late. I didn't want to be live too late because I have a early morning appointment. Um, yeah, we already seen that. So that one is the one when she came in and told us all, right? So we heard that. So I'm not going to read that because we saw it on the video, okay? So then we have page 13. We know they try to get him to reconsider and stuff like that. Okay, so 14. You know, I really think we should just read this first one first, okay? Don't be mad. And then we'll go to 14. So this is the verified petition for the mandamus. I think it's pretty interesting, actually, and then we'll continue. Okay, so in February 2017, Abigail Williams and Liberty German, more teenaged girls from Delphi, were murdered. Since then, the case has drawn more attention than perhaps any other case in Indiana history. There's one more bigger. How do I sound a little bit louder with it being high, you guys? How does that sound? Does it sound better? Okay, so it seemed like the world was watching when, in October 2022, the state announced that it had arrested Rick Allen for the girls' murders. In a matter of just days, Rick was taken into custody, moved to the DOC for his own safety, and appointed a special judge from another county. The trial court appointed Andrew Baldwin and Brad Rosie as Rick's public defenders. For the next year, Rick's attorneys have zealously advocated on Rick's behalf through exceptional circumstances. A gag order that was misapplied to the pleadings filed in court, a protective order in a case involving thousands of discovery items, a client who lost nearly half his body weight and began exhibiting symptoms of psychosis while enduring unduly restrictive conditions of confinement, intense media attention, exacerbated by a lack of access to the court records. Despite these challenges, Rick and his counsel made a strategic decision to be prepared to go to trial January 2024. They formulated a defense of third-party guilt, and they filed several substantive, thanks, Soul. Hey, Soul. Motions in pursuit of their trial strategy. In early October, counsel informed the court that Rick was all ready for trial in January 2024. 2 days later, the court instructed attorneys Baldwin and Rosie to cease working on Rick's case amid discovery that an acquaintance of attorney Baldwin secretly photographed and leaked to media a few pieces of discovery from the case. Attorneys Baldwin and Rosie were removed as Rick's counsel. Well, let me take this down. Who won? Hey, Mike. Rick's new attorney sought a lengthy continuance of the trial and admitted they did not know when they would be ready to proceed. Despite the exceptional circumstances, Rick has never wavered on this. Attorneys Baldwin and Rosie are his counsel of choice. At every opportunity, he has reaffirmed to the court that he wants them to remain as his counsel. Facts supporting the petition. After Rick was charged with 2 counts of murder, he was arrested and placed in the DOC for safekeeping. A special judge was appointed on his case, and he was assigned 2 public defenders, Andrew Baldwin and Brad Rosie. Action record of proceedings are... Attorneys Baldwin and Rosie were very skilled attorneys with a combined 50 years of criminal experience. Shortly after their appearance, Rick's lawyers issued a press release affirming Rick's innocence when the charging information and probable cause affidavit were released to the public. In response, the court entered a gag order. No, Mr. Rosebud, if you go into your settings, because sometimes it doesn't have the highest. So go into your settings and then put the highest resolution. A lot of times mine will get off, and you just have to you have to do it if that's what you're talking about. And a lot of them, for some reason, they were supposed to offer that, but sometimes it doesn't give you the option of 1080. I think it's with, oh yes, you're right, StreamYard. You have to pay extra. I have a paid subscription to StreamYard, but you have to pay extra for 1080. And my camera, my webcam, I don't think does 1080. I think that's why I never got it. But I'm gonna look into it. Okay. But still, though, go into your settings on the bottom of YouTube and make sure it's up. It should go up to 720 resolution, which makes a big difference. All right, so sorry. So shortly after their appearance, Rick's lawyers issued a press release affirming Rick's innocence when the charging information and probable cause affidavit were released to the public. Sorry, I already read that part. But in response, the court entered a gag order. The court also entered a protective order prohibiting the parties from divulging or otherwise granting access to the discovery relevant to this case. In the 11 months, attorneys Baldwin and Rosie represented Rick. They had 2 leaks of discovery material occur. The first instance was an inadvertent. Attorney Baldwin mistakenly sent a discovery log to a third party. Attorney Baldwin discovered his mistake later that day and rectified the matter. The second incident occurred after a close friend of Attorney Baldwin secretly photographed a few items of the discovery and leaked them to others, all without Attorney Baldwin's knowledge. Another challenge trial counsel faced was Rick's confinement in the DOC. The overly restrictive conditions Rick was subjected to led to a rapid decline in his physical and mental health. During the course of the representation, counsel filed motions with the trial court seeking to transfer Rick to another facility. To date, Rick remains in the same facility and under the same conditions of confinement. Yet through this, Rick and his attorneys adopted a trial strategy of seeking a speedy trial. They also formulated a detailed defense suggesting third-party guilt. And you'll see he filed a thing to speed up the trial. They said within like 70 days, I think it says. We'll read that. So they might get a quicker trial, but that's only if they let these judges, or these lawyers, I'm sure, because I'm sure if they don't, then the other lawyers there's no way they'll be ready in a couple months, right? All right, hold on one second, guys. Who won I just want to make sure I did these settings. Yeah, okay. Who won the gifted membership? Congrats, whoever did. Haunted Virgo, yay, congratulations. Sean, what up? Okay, so they began pursuing this trial strategy in defense by filing a number of substantive pretrial motions, including the following. A motion to suppress evidence, which will require a lengthy hearing involving multiple witnesses and exhibits. A motion in Lyman regarding the reliability of the firearm toolmark comparison evidence, which also require an evidentiary hearing with multiple experts. A motion requesting a hearing under Franks versus Delaware, which was accompanied by a lengthy memorandum and hundreds of pages of exhibits delivered to the court for its review. They also prepared a motion for speedy trial, which they plan to file in early November to confirm the January 2024 trial date. During a telephone conference between the parties and the court, Rick's attorney informed the court that they were going to trial in January 2024. Shortly after that telephone conference, the parties learned that some photographs had been taken and disseminated to the media of several discovery items. After some investigation, it was discovered that the leak occurred at Attorney Baldwin's office when a former employee surreptitiously accessed the discovery items and disseminated them, all without counsel's knowledge. Thereafter, both the state and the court discussed removing attorneys Baldwin and Rosie as Rick's counsel. Rick informed the court in writing that he was aware of the leak and still wished to have attorneys Baldwin and Rosie as his chosen counsel, but the court told counsel to cease working on the case until a hearing could be held. In in-chambers proceeding held on October 19th, 2023, the court told Rick's attorneys that she believed that they had engaged in gross negligence and that they could either withdraw from the case or be removed as Rick's counsel during the televised hearing in open court. Attorneys Baldwin and Rosie met with Rick and decided in order to avoid prejudicing Rick's defense and tainting the jury pool, they would withdraw as his attorneys. However, they told the court their withdrawal was involuntary, as they believed they were given no other choice by the court. Attorney Baldwin and Rosie left the courthouse, and Rick was immediately transported back to the DOC at the court's direction. At the hearing held in open court, the court noted that unexpected turn of events that were outside of our control and informed the public that Rick's attorney had withdrawn their appearance as his counsel. After the hearing, Rick's counsel notified the court that they had not formally withdrawn as Rick's counsel and that they were seeking the judge's recusal to rectify the prejudice Rick had suffered as a result of the court's actions. They also reasserted Rick's desire to proceed to the trial in January 2024. The court ordered the clerk to remove Rick's filings from the record, and it appointed 2 new attorneys to represent Rick. To preserve Rick's chosen trial strategy, attorneys Baldwin and Rosie entered their appearance as Rick's private counsel. In their appearances, they reasserted their position that they had been improperly removed as Rick's chosen counsel and that they were entering their appearances pro bono in order to preserve Rick's right to a speedy and fair trial with counsel of his choice. At a hearing held on October 31st, 2023, the court removed the attorneys Baldwin and Rosie as counsel. Over Rick's objection, the court noted its grave concerns about their representation and said it could not allow them to represent Rick. Thereafter, the new attorneys appointed to Rick's case admitted they could not tell the court with any certainty when they would be prepared for trial, given the massive amount of discovery, but they agreed to continue the trial to October 2024. The court also noted that once new counsel had time to review the case, they could decide whether to adopt the pleadings filed as a part of Rick's trial strategy in defense or abandon them in favor of their own. The day after attorneys Baldwin and Rosie were removed from Rick's case, undersigned counsel contacted the court reporter to make arrangements to prepare an expedited transcript of the relevant proceedings to file this original action. Jurisdictional statements and original action standards. This court has jurisdiction over the petition as an original action. The application has been made expeditiously, after the jurisdiction of the respondent court became an issue. As developed below and in the accompanying brief, the respondent court has exceeded its jurisdiction in its removal of Rick's counsel of choice. Okay, so let me skip a little bit here. Where are we at? Noting writ of mandamus will issue where trial court has failed to perform a clear, absolute, and imperative duty imposed by law. As explained below and in the accompanying brief, the denial of this petition will result in extreme hardship, and the remedy available by appeal will be wholly inadequate. Rule of the rules procedure for original actions contain a required condition precedent that the subject matter of the original action must be raised and ruled on by the trial court prior to the filing of an original action. As be explained more fully below and in the accompanying brief, the subject matter of this action was raised below in at least one motion alleging the trial court lacked jurisdiction to act in the manner in which it did. The trial court ruled on that motion. I might skip all these examples here since we have so much to read. All the, whatever you call that, where they bring in other cases. But if anybody wants to see it, I could email it. Just because we have so much other stuff. Wait, hold on. Let me see. I'm going to skip. So they're talking about there are only 2 situations where a trial court can sever the attorney-client relationship. Wheat versus U.S. First, a person may be removed as counsel from a case where the person is not a member of the state bar. Second, an attorney may be removed as counsel when the representation presents an actual conflict of interest. In this situation, however, courts must be careful not to remove counsel where the government has created a conflict to prevent the defendant from having competent counsel. Let me make sure that... Says the attorney-client relationship once established is inviolate. This is true and regardless of whether the attorney was retained by a client or appointed as public defender. So I guess some of this it is kind of important. Says a criminal defendant in Indiana has a federal and state constitutional right not only to counsel, but to counsel of his choice. Yeah, that's huge right there, I feel like. Sorry, I'm going backwards now. And courts across the country regularly issue extraordinary writs in criminal cases to reinstate defense attorneys who have been removed from cases for conduct the trial court found upsetting or negligent. So court across the country regularly issue extraordinary writs in criminal cases used to reinstate defense attorney. Okay. So this is looking like, well, of course, I mean, they're trying to argue their point, so hopefully, I hope they let them stay, guys. It says, let's see, writ of mandamus appropriate or lawyer removed because judge had personal belief that an alternative public defender would be better. Mandate and lawyer reinstate and following removal for conduct that upset the judge. Okay, so let me just see something real quick. Yeah. All right, so let's go down. We already read the conflict of interest, if that's the case, but it's not. A trial court has no authority to remove an attorney over a disagreement as to the conduct of the defense. It's Harlan versus United States. This court is generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. However, the court finds it unnecessary to explicate the perimeters of the authority here. Moreover, before a lawyer may be removed as counsel, the court should exhaust other possible remedies, such as censure, referral to the disciplinary commission, or contempt proceedings. The process of removing an attorney in the two narrow situations noted above can only be done after notice and the opportunity for the defendant to be heard in open court on the matter of his counsel. It was inappropriate for the trial court to remove counsel summarily. Oh my Lord, I can't talk. Without a hearing or prior warning of the courts concerned. So yeah, just the way she went about it. Like, I know some people argue, well, no, I mean, she was allowed to disqualify them, you know, and I don't know how many people are in the favor of her. I don't think well, I'm sure there are a lot, but the way she went about it, though, is not cool. Like, that was so messed up the way she went about it. And I still think that they shouldn't be disqualified. But especially the way she went about doing it, I don't think is proper. So, and the fact that the attorney general is refusing to represent her, that says something, does it not? I feel like, why? Why doesn't he want to represent her when normally that's who would represent the judge, right? Nope, he declined. So, okay, so let me see here. Neither of the narrow situations that allow for removal of counsel existed in this case. Let me make it bigger, sorry. Attorneys Baldwin and Rosie are active members of the Indiana Bar and are in good standing. No conflict of interest was even alleged between Rick and his attorneys. Rather, the alleged acts of gross negligence the court cited to remove attorneys Baldwin and Rosie were either a mere disagreement with their zealous defense tactics or concerns about the unintended release of some discovery material. Yet the discovery leaks did not create a conflict of interest or otherwise have any effect on the relationship between Rick and his attorneys. Moreover, trial counsel took additional steps to ensure another unintended release would not occur. The trial court held no hearing before removal of counsel, depriving Rick and his attorneys of the opportunity to be heard on the matter. The court also did not attempt to exhaust alternative remedies before permanently severing the attorney-client relationship, even though attorneys Baldwin and Rosie suggested a remedy in the event that the court was considering a removal. In sum, once attorneys Baldwin and Rosie were appointed and became Rick's counsel, the court lacked any authority under these circumstances to sever that relationship. The court should grant This court should grant emergency relief and temporarily stay the proceedings below until a permanent writ is issued. Without a stay and quick resolution of this action, new counsel may withdraw the motions filed by attorneys Baldwin and Rosie. or the court may summarily I can't say that word for some reason, rule on them. Wait, let me read this again. Counsel may withdraw the motions of attorneys. Okay. This court should grant emergency relief and immediately reinstate attorneys Baldwin and Rosie as Rick's attorneys. Each day attorneys Rosie and Baldwin are off the case, Rick's trial strategy is placed in grave peril. That's true, man. Like, like how many weeks has this been going on where they're not even working on the case, they're worrying about all this. And his remedy on appeal is non-existent. No appealable judgment has issued in the case, and even if it had, attorney Rosie and Baldwin's appearances have been rejected such that they cannot perfect an appeal in any event. Instead, the trial court continues to conduct proceedings at which Rick's rights will be affected and the course of his ongoing trial strategy will be determined without the benefit of his chosen counsel. The exercise of this court's original jurisdiction is appropriate. This court should also order Rick's trial to commence within 70 days of the issuance of a writ. Rick and his attorneys developed a speedy trial strategy and plan to confirm the January date by filing a speedy trial request in early November. The new attorneys appointed to Rick's case have already asked and received a new trial date in October 2024. They have also indicated they cannot be certain they will not need another continuance to prepare for trial. Finally, this court should remove the special judge assigned to this case and order appointment of a new special judge. Indiana Judicial Conduct Rule 211 requires a judge to disqualify herself in any proceeding in which the judge's impartiality might reasonably be questioned, including circumstances where the judge has a bias or prejudice concerning a party or party's lawyer, which I think it's pretty clear here. I think she has a bias in both, to be honest. And then here, the judge believed counsel was grossly negligent and expressed grave concerns about the representation. She I cannot talk, you guys. Oh my Lord. Emphatically stated to Rick that she could not allow them to be his attorneys, given her concerns. And I don't know if you guys watched my live last time, but she actually, this guy was trying to represent himself, but still, isn't he allowed? She wouldn't on another case, she wouldn't let the guy fire his lawyers. What the heck? Like, the international media attention this case has received suggests that for many people following the case, this may be their first time observing an Indiana court proceeding. Rick had a carefully formulated trial strategy and a detailed defense suggesting third-party guilt. The substantive pretrial motions he has filed to further his strategy and pursue his defense have yet to be ruled on. Yeah, she didn't even rule on a lot of stuff that should have been ruled on by now, considering the trial was supposed to be January, right? Going forward, the public will question the judge's impartiality with respect to her rulings. To restore the public's trust in the integrity of the judicial process in this high-profile case, a new special judge should be appointed. Statement of precise relief sought. Realtor respectfully requests that the permanent writ of mandamus be issued, mandating that the trial court reinstate attorneys Baldwin and Rosie as Rick's court-appointed counsel, mandating that the trial court order Rick's trial to commence within 70 days from the issuance of the writ, and a mandating that the special judge be removed from Rick's case and a new special judge be appointed. I hope all three of those happen. I really do. And then, that's the end of that one. We got Mark Lehman, Kara Schaefer. Okay. So let me check that off. We read that. I didn't even have that on the list to read, but I knew I wanted to read it. Okay, so let's go to the October 21 to 31. Oh, it's on the 41-page document. That's what I need to get. Okay, here we go. Okay. Oh, I want to see why I skipped those. Oh, yeah, because we already saw that. Okay, so let's go to 21. Okay, so this is October 31st hearing. McClellan, Luttrell, Labrato, Scrumman, Judge Francis, Jody Williams. So we have. Dang, actually, I should have you come up and read the back and forth. But the only thing is there's more than two people. Wait, there's the court, there's Nick, Luttrell. I guess one person could do the court, and one person could just do all the, oh no, we have, oh yeah, well, I guess somebody could do the court and, defense, and somebody could do the court and the prosecution, but it's 10 pages, so, okay, okay, I gotta take some water, hold on, take some water like it's, all right, why did I skip down? Oh yeah, here we go. So the court says, we are on the record. Thank you, Karen. All right, are we ready? Is the state ready? So McLean says, yes, Your Honor. Yes, Your Honor. Well, Ashley, would you be able to hurry up and come real quick if you come up to do it? Or should I just like work on something else first and then give you time? I could do like I could do the affidavits first. Here, I'm going to send a link and I'll do the affidavits first and then give you a minute to come up and then you could read this with me. Wait, are the crickets eaten already? All right, I'm gonna put it in the chat, so just grab it, Ashley. Wait, you're gonna do it like right now? Should I start on something else or no? I could start on like the Mitch affidavit is only like a paragraph. I'll do that I'll do the Mitch one real quick. Okay. Just 34 and then we'll go back to 21. So Mitch Westerman, I'm going to read. He's the one that actually took the pictures. He's the one that stole the pictures. Took the pictures of the crime scene. So this is 34. All right. Yeah, just come on, Ashley, when you're ready. I'm just going to read this. It's really short. So, affidavit comes now, Mitch Westerman being first duly sworn under oath and states that the following information is within his personal knowledge and is true to the best of his knowledge. I was in attorney Andrew Baldwin's office building waiting to visit with Andrew. He was in his office either meeting with a client or on a telephone call with the door closed. I went into the conference room to wait. I observed printed copies of photo evidence on the conference room table. I took pictures of a few of them. Andrew Baldwin did not give me permission to take the photos of the printed copies. He was not present and he did not have any knowledge that I took pictures of the evidence photos. I am freely and voluntarily typing and signing this affidavit on my own accord because it is the truth. So there you go. Like how could he, like, I don't think Baldwin should get in trouble at all for this because that's like, he got robbed basically. You know what I'm saying? Like somebody stole from him. How can he be to blame on this? I'm sorry. Now the mistake of him sending the email, that you can maybe argue, but I still think, mistakes happen, but that one you could possibly, but this one, like I feel like there's nothing, like you can't blame him for that. So I think the other one, we'd have to see what did he accidentally send to Woodhouse, because maybe it was nothing. I don't know. Maybe it wasn't anything big. Who knows? But this for sure, this is not his fault. I'm sorry. No, what do you mean, Melly? What Woodhouse videos? Which ones are you referring to? Not the ones he deleted originally. I got like a couple screenshots. Just the ones that I think he still has those ones up. The ones that's like part 1 and part 2. Well, he has a few. He has like a channel, so he has more than those up. But okay, so yeah, so we have that. Hi, Colette. Now we'll do 36. Ashley, are you coming still then? Or no? So 36. Oh, there you are. Okay. Hold on. Let me just do this one since I did the affidavit of Mitch real quick. Let me just do this and then we'll start. Okay. Because this is attorneys Bradley, Rosie, and Andrew Baldwin, their affidavit. Oh, thanks, Soul. You doing another one? Thank you. Hey, C-Star. Okay, so Attorney Baldwin is one of only 4 Indiana attorneys certified as criminal trial specialists by the National Board of Trial Advocacy as authorized under Indiana Rule of Professional Conduct 7-4. Attorney Baldwin has represented thousands of clients all over the state of Indiana during his career, which has spanned nearly 30 years. Many of the clients have been accused of murder, robbery, burglary, and various other serious violent offenses. Hi, Thomas. What up? Who won? Soul, who won who got the thing? It doesn't come up as far as who got it on my side. Whoever got the membership. Okay. Where are we at? Additionally, he estimates he has represented clients in more than 125 jury trials over the course of his career. On multiple occasions, Attorney Baldwin has been asked to teach trial techniques to lawyers, young and old, at the Indiana Public Defender Council's annual week-long Trial Practice Institute. In the past 2.5 years alone, Attorney Baldwin has represented at least 5 clients charged with murder. Attorney Baldwin has never been disciplined in any way as a lawyer during his nearly 30-year career. Attorney Rosie has a BS in criminal justice and an MS in criminology and was previously employed by the Indiana Department of Corrections, Marion County Pretrial Service Agency, and also worked as a private investigator investigating both criminal and civil matters before obtaining his law degree. Attorney Rosie has over 20 years of criminal trial experience, handling thousands of cases, including 8 murder cases, 3 of which have been tried to juries. Attorney Rosie has also tried various other major felony cases, including, but not limited to, cases involving child molest. I wonder why they wrote it like that, huh? Attempted murder, robbery, and burglary charges. Attorney Rosie was previously certified to handle death penalty cases. Attorney Rosie, God, I keep forgetting. That just seems like it should be Rosie. But, okay. Attorney Rosie practices regularly in Carroll County, where these crimes occurred, and in surrounding counties, and is very familiar with the geographic area near which these crimes were committed. Attorney Rosie is the designated Cass County representative for character and fitness interviews associated with newly sworn attorneys. This appointment came by way of a recommendation from the Honorable Judge Lisa Swaim, Cass County Superior Court 2. Attorney Rosie has never been disciplined in any way as a lawyer during his 20-plus year career. Richard Allen desires Attorney Baldwin and Rosie continue to represent him to see this matter to a conclusion. Richard Allen has asserted that this in writing and orally in open court as recently as October 31st. On August 17th, Max Baker and Attorney Rosie visited Richard at the Westville Correctional Facility. During that visit, Rosie tendered a motion for early trial to the client, Richard Allen. Attorney Rosie further explained to Richard that the desire of his attorneys to use the motion to firm up the January 8th, 2024 jury trial setting by filing the motion sometime during the early portion of November 2023. Richard Allen signed the motion, and Attorney Rosie maintained the original motion, undated, in his office and continues to possess the signed motion. On October 4th, 2023, Prosecutor McClellan Attorney Baldwin and Judge Gall and Attorney Rosie participated in a phone conference regarding motion requests that were filed by Defendant Allen on or about October 2nd, 2023, including defendant's motion for discovery deadline. During this phone conference, Judge Gall commented that she assumed the defense's request for a discovery deadline was intended to support a request to continue the January 24th trial date. Where are we at? Okay, so Attorney Baldwin then communicated to Judge Gall and Prosecutor McClellan that the defense was not interested in a continuance and, in fact, intended to go on to trial on January 8th. The parties participated in a telephone conference with the court on October 10th, 2023, to discuss the matter of Westerman's surreptitiously taking photos of crime scene photos and the deposition exhibits prepared by the defense. During this phone conference, the state suggested that the disqualification of defense counsel might be appropriate. In response and during the same phone call, Judge Gall then indicated to the parties that she was leaning toward disqualification but mentioned no rationale for her comments. So that's kind of interesting, actually. So these parties. So it doesn't look like it was as big of a surprise as the Rosie and Baldwin. Ashley, I'm going to add you up. Okay. What up? What up?
Hi, how are you?
I'm good. How are you?
I'm good.
What do you think of that last part, though? So they weren't, it wasn't like a big surprise. If this is true, which Andrew Baldwin's the one writing it, so he is saying that she was leaning, that she had told him that they were leaning towards disqualification. So, but it was still wrong how she gave him the alter, like, oh, I'm going to do this or this. You know what I'm saying?
Yeah, like resign or you're being fired.
Yeah, just the way that it seems like it happened, it doesn't seem right. And there's, other things that just don't seem right about everything. But as far as them saying, oh, like, this came out of nowhere, obviously that's not true because, look, that shows. So.
They were told, yeah. I mean,
and they said, look, and it says that she was leaning toward disqualification. But the thing is I still don't agree with the disqualification thing. I don't think they should be disqualified for that, to be honest.
Yeah, I don't either. I mean, the guy even admitted that he took the pictures without him even in the room. He had no idea. I mean, if he was right there and he had known about it, then, or, if it even happened under his nose, even if he said no, I could maybe see it. But without him even knowing it happened at all, I think it's kind of unfair. And Richard Allen's the one that has to suffer this, I mean, I'm not to say that, a murderer shouldn't have to suffer, but if he's an innocent man, that you don't ever want that,
No, you're right. Yeah, it's not right. Here, I'm going to highlight. You can keep talking. I'm going to highlight, like, so we know who's doing what.
Right.
It's not going to be any system necessarily because, look, we're going to have to go. I was going to do like prosecution and then defense being separate, but the way this is, it's not going to work. So I'm going to do it a different way here. Okay, so.
All right.
But yeah, go ahead. So what else have you thought? Like, what else? What about from that live, the stuff, my last live? Do you have any comments about that?
Oh no, I forget what we even talked about the last one.
Oh, well, yeah, there's a bunch of stuff, huh?
Yeah. Just this whole thing, I feel like his counsel should be able to have the counsel he wants, just in my opinion. I mean, I don't care if it was the day prior to trial. He should be able to choose who he wants to be his lawyers. I understand, like I said, if the judge, like, I don't know, does really think that they're jeopardizing the trial or anything, but, under the nose, I don't know how you could think that was him purposely jeopardizing anything just because he left it on a table. I don't know. Not thinking anyone would even go there, I don't know. It's weird. I've never seen anything like this ever.
Yeah, no, this is crazy. Yeah, me either. Yeah, this is hard to, like, for this to, hold on. So I'm somebody that keeps a court. What else? What about? I don't know what else to ask here. Hold on, because if I don't do this, we're not gonna know who does what here.
Right.
What
Yeah.
else
It's all
here?
kind
Think
of
of some. What else do
together.
you want to talk about here? I don't want to just sit here quiet. Let's
Yeah,
see
right.
here. Do you have anything
Um,
else to?
let me think of something. Probably,
Sorry, I kind of put you on the spot,
yeah,
huh?
I did have a question, but I forgot what I was gonna even ask now. Um, crap. Oh, wasn't it Baldwin's office? Oh, that the
Yeah.
wasn't it
Yeah.
Baldwin that the papers were? Okay, so it
Yeah.
was Baldwin. I wasn't for sure if it was Rosie or Baldwin, but or Rosie or Baldwin.
Yeah, it was Baldwin's office. Now
That's
I'm
crazy.
really curious on what was leaked or
So
what
the
was
guy just
sent
went in
to.
and took a picture of it.
Yeah. But I want to know what was sent to
Yeah, because didn't he also accidentally
Woodhouse.
email somebody?
Yes, but there he makes it seem like it wasn't
Yeah,
much, but
yeah.
Woodhouse makes it seem like it was. So what the heck? Was it or not?
Right.
You know? What do you think?
Well, he probably like Baldwin would probably try.
To keep them, he should freaking be able to keep them. I'm sorry.
I
You
totally
know?
agree.
And I think as far as
Yeah,
like bigger picture, if you look at who's like wrong, like the state or the defense attorney, like the state, I feel like all the corruption and stuff, like who is really like if you look deep into it, who is
yeah.
really the shady people doing some shady stuff? It is the freaking state. I'm sorry.
Oh, hell yeah. I'm with you there. I know just from experience. The state is very shady.
Man, we might have to take turns on the court because, so we have at least somebody's not talking
That's
like
all
the
right.
most. You know what I'm saying? So now we'll
Right.
switch to the court. Hold on 1 second. So now the court will be. So wait. So blue was McClelland. Okay, so we'll keep blue with McClelland in the prosecution. But anyway, what else? Do you believe Woodhouse?
1 sec.
Blue is McClelland. Mm. Dang it. So Librato. You guys, sorry, I'm just highlighting it because she's going to help me read. And this is like the transcripts. And I'm just highlighting so we know who goes where. So it's just I'm trying to just do it. We're not always going to be the same people, unfortunately. It's just not going to work out with only two people. So,
That's all right. It doesn't matter to me. Sorry, what did you ask a minute ago? I said 1 sec too because my dad was talking to me.
I don't know. Oh, do you believe Woodhouse? How did you feel about Woodhouse? Like his
I
stuff.
feel I don't know. I believe him a little bit with like because he's trying to like make it seem like there was more to the email than what Baldwin was, but I don't know. I've got to probably believe Woodhouse with that one because, like I said, I feel like Baldwin would try to diminish like what he sent. I mean, just for self-preservation. Like, I don't know though. I would have to
No,
see what it had to do with.
more. I mean like more than that too. Like as far as
Oh,
like
yeah, I don't know like a whole lot about him. But
okay.
he seems kind of shady in my opinion a little. Just a bit.
So you don't believe like the
Just from what
stuff
I
that he
know.
was saying about what McClelland did to him and stuff, you don't think? Or did you watch that part or no?
Well, I don't know about all that.
Okay.
I don't
Okay.
know if I watched that part. What did he do?
Just like the stuff like about the taking pictures of him, giving him some kind of medic drugs that
Oh,
made
that.
him.
Oh, I didn't hear anything about drugs.
Yeah, supposedly he gave him. He made it seem like he gave him supposed to be like his medication, but he gave him these pills that might not have been, and then it made him like pass out basically. And then that's when they like took pictures of him with the syringes and stuff.
Oh, crap. Yeah, I didn't even know about that. I must not have, like, been listening or something at one point, but holy crap. Yeah, that's a little intense, if that did happen, wow.
Yeah. Okay, so I got that done. Okay, so do you want to be? I try to make it as even as possible. Do you want to be the blue or?
Yeah, I can do the blue.
Okay. So you guys remember, she's not. We're not going to always be the same people. So sometimes she's going to be the court, but it's just going to make it a little bit easy to follow to where it's just at least two people. Well, hopefully you guys will be able to see who's what's what, right? Can they? You think they could see? Who's okay?
Yeah.
So this is from October
Yeah,
31st
I think they
hearing,
can see alright.
which we didn't get to hear. We didn't get to see it because they didn't allow cameras. So at least we get to read it.
I know.
I don't know if
True.
anybody's interested. It doesn't look like it, and we only have 65 people now. But oh well. Okay, so go ahead.
Alright, we're on the record. Thank you, Karen. Alright. Are we ready? Is the state ready?
Yes, yes, Your Honor.
Yes, Your Honor. Defense ready? Yes.
Yes.
We are on the record in the state of Indiana versus Richard Allen. I'll show that the state is hereby Mr. McClelland, Mr. Luttrell. Defense is hereby Mr. Librato, Mr. Scremin, and I note yesterday late the written appearance by Mr. Rosie and Mr. Baldwin. So we are here, Mr. Librato. Either this morning you filed a motion to continue the jury trial.
That's correct, Your Honor.
Go ahead, sir.
I explained that to Mr. Allen.
Okay, and what is the state's position?
Judge, the state has no objection as long as the time is chargeable to the defendant.
Okay.
And Your Honor, that's in our motion that we would accept all the CR4 time.
Yeah, I show in paragraph 4 the state doesn't object as long as CR4 is charged to the defendant. Okay, so then we have the appearances by Mr. Rosie and Mr. Baldwin. Gentlemen?
Judge, Mr. Allen has asked us to represent him, and we entered our appearance to represent him.
Okay, well, as we had our hearing on the 19th, prior to that hearing, we had some discussions. Counsel, you chose to withdraw from the case rather than be removed for gross negligence. What's changed in the 12 days?
Well, Judge, I think I made it abundantly clear in my pleadings with the court that the conduct of the tribunal in the chambers a week and a half ago left us with no choice but to withdraw because we were going to put ourselves in a direct conflict with our client by sitting in the courtroom and accepting, what was lashing essentially from Your Honor. And so that was a strategic move so as to protect our client's rights. And I think I made that abundantly clear. I don't know how that could be clear at this point, how that couldn't be clear at this point. Beyond that, us transitioning from the contracted public defenders to the private counsel puts us in an entirely different situation with our client, which is the Sixth Amendment, his Sixth Amendment right to have representation. And to the extent that the court is trying to intervene into that right without some due process, it's my client's contention that that's just not appropriate. And he has the right to have counsel of choice. So I don't really know that there's much else to say. I think in the normal course of business, I'm a private practitioner. I was once a public defender. In the normal course of business and in every other case I've ever been involved with, when there's a public defender assigned to a case, such as Mr. Scrumman and Mr. Librato, excuse me if I messed your name up, but in every other case, when private counsel enters their appearance, the public defender taps out and basically private counsel gets up and running. And I don't see why this case should be any different.
Well, again, you haven't answered my question that nothing has changed in the 12 days since I found gross negligence on the part of the defense in representing Mr. Allen.
Well, the answer to the question is that we didn't act grossly negligent. And the court has an opinion that's different than our opinion. And, at this point, without some due process and some findings, with a notice and an opportunity to be heard, that we're just on a different page about how we acted and what our circumstances are. So that's the answer to that question.
Does the state have any opinions or wish to weigh in? Judge, I guess I'm at a loss at this point. We've struggled up to this point, Judge, and again, I was there in chambers in the meeting. I agree with the statements made by the court about the defense being grossly negligent. Again, this started back at our first hearing back in, I believe, in November, with the actions outlined by the court about the defense's statement in chambers, and then a kind of a direct 180 from that statement once they left chambers. And then there was a leak from defense in December that wasn't made aware to the state or to the court until the state found out. Then we have various motions that were filed with not only negligent statements, Judge, but I think outright lies, and I think that's been proven in court and hearings that we've had. We then have the Franks motion. That was filed, Judge. That what you have to outline in a Franks motion is very clear. And defense counsel spent over 100 pages outlining their theory of the case instead of argument for the Franks. And again, I think everything they've done, including the most recent leak, is just an effort by them to push this case out into the public and try this in the public eye and not in this court. The state's concern is that Mr. Allen has a fair trial, and that is the state's concern. But that goes both ways. We deserve a fair trial too, Judge. That right goes both ways. And I just don't think the actions by the defense can be attributable to anything else but gross negligence, Judge. And so that's the state's opinion.
Mr. Allen, I understand that you wish to have Mr. Baldwin and Mr. Rosie represent you in this matter. I have grave concerns, Mr. Allen, about their representation of you. The previous findings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know what you want. You've indicated that through your attorneys. But I cannot and will not allow these attorneys to represent you with the concerns that I've had, with the gross negligence that I have found. They withdrew rather than be found grossly negligent and be removed. I can't do it, sir. I just can't.
Judge.
Let me finish. I cannot allow that. I have appointed able counsel to represent you. Mr. Scrumman is here. Mr. Labrato is here. They have an investigator here as well, and I will grant their motion to continue your trial. Let me just mention, while he's sitting in prison being treated like crap, for another year, freaking,
Yeah.
You know what I'm saying? Like, where he was supposed to have the trial in January.
I'm honestly not even sure he'll make it to the trial date just by what he looks like. Yeah.
Yeah. Plankton.
It makes me wonder if that's almost kind of a plan, It's weird. It's just all coincidental.
I wonder, now that we saw their records, like Baldwin and how good they are, like I wonder even also if they're afraid that he could be found possibly not guilty, and they don't want that. You know what I'm saying? Because then it looks like the state failed kind of to find the person in a way. So I wonder if that comes into play.
Yeah.
Like if they're afraid that if these lawyers, they might just be able to get a not guilty conviction. Which is that's bullcrap, Like,
yeah.
Anyway, where are we at? Okay, so Let me finish. I cannot allow that. I have appointed able counsel to represent you. Oh, sorry, I'm repeating it. Oh, well. Mr. Scrumman is here. Mr. Labrato is here. They have an investigator here as well. And I will grant their motion to continue your trial. And I'm sorry this is happening to you, Mr. Allen. Mr. Labrato, Mr. Scrumman, I know that you have not talked with the state. I know you have not yet received discovery. There is no way that you can tell me when you will be ready for trial. I have asked former counsel to cooperate. I have asked former counsel to provide the discovery to you. It's my understanding that Mr. McClelland, you've indicated that that has not been provided to you.
Correct, Your Honor.
Gentlemen, when can I expect that you would return the discovery to the state? By the end of the week, perhaps today?
That would be great. If you could get it today, that would be wonderful. Then that can be provided to successor counsel. You are not required to cooperate with successor counsel. I would hope that you would in Mr. Allen's best interest, but that is entirely up to you. If you could have the discovery to the state by the end of this week, that would be great. I know that I'd previously entered an order that discovery was to be complete by November 1st. Obviously, that's not going to happen. Do you want to pick up? Do you want to pick a trial date, Mr. Librato, Mr. Scremin?
Yes, Your Honor. Briefly speaking with the state tentatively, we would like a trial date in November, but not knowing what exactly we're going to be getting. I can't tell the court with any certainty that we would be ready in November. We will do everything in our power to be ready by then. It's my understanding that it's a massive amount of discovery.
It is. Karen, I know that you brought the calendar in. Could we get a date in November? Okay. I'm looking at November of 2024. There's an election day, there's Veterans Day, and then Thanksgiving. If October or December would work better.
Oh, shoot, I screwed
October?
this up. Oh, well.
That's fine, Judge. The state, whatever is fine with the court is fine with the state, Judge. Mr. Scremin, Mr. Librato.
October would be fine, Your Honor, for a start.
Then why don't we look? October 14th is marked off. What is that?
Columbus Day, Your Honor.
Columbus Day. Thank you, Karen. You may mark that off. So we'll look at October 15th through the 31st. Fine, Judge. And we again would pick the jury in Fort Wayne and bring them here to Carroll County for the trial. There's a pending motion to suppress. There is the Franks that is not yet. I haven't finished even reading it or going through all of the hours of interviews that were provided on a flash drive. So you'll need a hearing date for that. Once you get the discovery and once you've had the opportunity to review the pleadings, you could either adopt those pleadings or make your own. It's up to you. Anything else from the state?
Judge, we want to create a record. To be clear on what you're doing, you are disqualifying Brad and me. Is that correct?
Correct.
Wow, I think we have like a 5-second delay. Huh. Well, I'm gonna count next
Let
time.
me
It's
refresh
really
it.
delayed. Yeah. At first, I was thinking it
I'm gonna
was
refresh it. Yeah, I've been trying to. Yeah, I've
maybe
been
just
trying to
like
figure it out. I don't know why. Hold on.
so maybe yeah. Why we gotta figure this out because it's gonna make it hard to go back and forth because it's that I should count. I should count how long it is before you guys probably hear it right here. But you know what, Ashley? You know what's weird though? Last time, I don't know if you're still there because I think she's refreshing. But last time
What?
I heard the delay majorly, and then when I listened to parts of the live back, there was actually no delay live. But I'm hearing it. So it's weird. It's like live. I don't know about right now, but that one where like live it was like I was expecting it live, it like worked out. And then I'm like, why? So I was trying to figure out in my head, well, why am I hearing it delayed? But the live isn't. Are you guys hearing it delayed or no? Cause it's like 5 seconds for me. Like I'm done reading and I'm
That's
like
really
sitting here for a
weird.
while. But I don't know. I'm trying to figure out how could that be possible that it's more delayed for me than when it's live though. How I'm trying to like technically figure that out. What would be going on here? You know what I'm saying? Yeah, see, Patty's saying it's not delayed. So, Patty, what I'm talking about is after I'm
Right?
done
Yeah, that is kind
reading.
of weird. I don't know.
See what I'm saying? See, okay, see, after I'm done reading like the sentence, see how long it takes her to continue. And it might not be because that last live it wasn't for anybody. Yeah, I don't know, Ashley, I don't know, but for me it is. So I feel like it's like gonna make me interrupt you, or it's gonna make, I don't know. We'll try to figure it out. I hope it's not delayed. Oh, so Brian's saying it's delayed. Well, I don't know. I'm gonna go back and listen to it later and see how bad it is. But let's try. Where are we at now? Oh, so are you
Well,
there?
what I'll do real quick, if you want to just wait a second, yeah, I'm here. So what I'm actually gonna
See,
do is, if you'll give me
see.
just 1 second, what I'm gonna do is I'm gonna get on my phone, because it seems to work a lot better for my phone. So I'll
Okay.
do that, but I'll read it from the computer. So it's just easier.
Okay.
But so
Cool.
I'll be in here twice, but yeah,
Let me know when you come
hold on.
back. Okay. What kind of ISP? What
Sure
is
will.
ISP? I don't know what that means. What is ISP? I should probably know. Wait, it probably delays Ivgar, so she's not ahead of us. Yeah, it's really bad. But it was even like the last couple times that I had her on, like for me, it's really bad. So therefore, like I'll say something and then she'll respond to what I'm saying, but I'm already like thinking she didn't respond, so I'm saying something else. So then she'll interrupt me, or the other way around, where I'll start talking because the delay it makes it hard because it'll make us talk over each other because we're not realizing. I don't know how to explain it. I guess you'd have to like experience it yourself, and you'll see it's very hard, especially if it depends on how much the delay. And this one is really bad for me, at least. It really is. Oh, my internet provider, it's Spectrum. No, I have good internet. I have like I pay for the higher speed. Like I pay for an extra, like just you have the regular high speed. Well, I pay for like one of the higher ones. Um, I think there's one above me, which I'm gonna look into
That's what I
that.
have
But
too.
I pay for an extra for because I know it's the streaming. Are you there?
Oh, this is still from my laptop. Hold on.
Oh,
I'm signing into YouTube on
okay.
StreamYard.
Did you guys see? Did you guys see how long though? From when I asked. Okay.
Somebody said 2 seconds. I saw somebody.
But even if it's 2 seconds, that's still a problem because think about it. Like, it's going to cause us to interrupt. It's going to, I don't know. It's just, oh, shoot.
I
What page was
agree.
I on?
Yeah, I'll just fix this by getting on my oh crap.
Man, I
Oh,
really
right down
screwed
there.
up.
I think it was like close to 8, 9, 10, 14 maybe. I don't know.
Hold on one second.
Something.
I thought it was, oh, yeah, we were over here. Okay, hold on one second. Oh, no, no, we didn't go. Because it started at, wait, hold on. It started at 21. Wait, where? Hold on. Let me figure this out. Oh, yeah, we did that. We did that. Wait, why am I like remembering us doing that, but then not? Oh, she did this. She talked about the Franks, and she didn't get it done yet, which is. No, that's Mr. McClellan. No, wait.
Okay, I'm backstage on my phone as
Okay.
well.
Why am I not being able to figure out where we left off? I don't even remembering this. You think it's what? No, Your Honor, thank you. I don't know. I don't know where we just left off, guys. Were we just almost done, really? No, Hennessy didn't talk yet, right?
No.
Do you know where we were? I don't know why I'm having trouble. Can you hear me?
Yeah, I hear you on my computer. I'm like my phone just died. It was I was in it and then it died on me. So
I think we're right here, right?
what I'll have to do is I'll
Okay.
have to come in like stay in on my computer, but also on my phone so that way I can actually see it big enough to read it from my computer.
So wait, are you saying you're ready or not yet? I'm confused. You're not ready or you are? I don't know what you're saying.
Not yet.
Oh, okay.
Not yet.
Well, you just let me know when you are. Okay. So I think we're on 28 right here, right? Let me make sure I have like the
Just give me a
highlighted
sec.
stuff better. So I have wait, court order, McClellan. Oh, I have that together. Hold on. Let me do. Oh, I put it together because I was being McClellan, but I guess I don't have to since we're already mixing it up. So we're on 28, so we don't have much more to go. So you were the blue. Yeah, we only have a couple pages to go. So just bear with us, guys. There's more stuff, too, that I want to read to you, too. She's just trying to redo it. Because with all the different people, it's like it was going to be confusing if I read all of it. Hey, Capricorn. Morningstar. How are you guys doing? Let me see if I could find anything else interesting while I'm waiting for her here. Hold on. I know I was planning on actually just doing, breaking up some clips and stuff for my last live since it was so long, but then I saw some of these documents and I'm like, ooh, I should do a live for these, but, maybe I'll be able to finish this kind of soon so I could still do some pre-records. Whoa, somebody did. Here, let me just share. I'm on a Facebook group. Let me just like share what I'm looking at right now while we're waiting for. Hold on one second. Might as well. Let's just look together since. I was just going on this Facebook. Somebody has a Keegan client. Does this look? Yeah, dude, I did a face overlay of Keegan, like a bunch of Keegan pictures with that, and it's like crazy how much he actually looks like this one, like the nose and the eyes and stuff. But the thing is I don't think it was. For some reason, I don't think that he was him because Keegan's pretty big, right? Wouldn't they have like described him as like a bigger? I mean, did they even say that? And then here's the thing. Now afterwards, we're seeing like the whole stuff with Keegan's coming out, Richard Allen, all this stuff's coming out. What these witnesses? What are they saying now? Are they saying now that they have somebody to compare it to? They're the ones that saw these guys. You know what I'm saying? What do they say? Like with Richard, if they're gonna bring the witnesses up, and are they gonna be able to remember and be like, "Oh my God, yeah, that's who I saw"? Or what about the I always get confused which one says what. The Young sketch. I have my notes here. The Young sketch was Betsy. So is Betsy can Betsy look at Keegan and be like, because she got a good look. Remember, she said she got a good look at him. Can she like tell us? Oh wait, that was Keegan. Or no, that wasn't. I mean, you know what I'm saying? You think she would, if she got a really good look at him, you think she'd be able to possibly say if it was or oh yeah, that's Elvis, or you know what I'm saying? You think they would be able to possibly say that? Now Sarah, the one that's seen him from the road, I don't think she got as good of a look of that person as we imagine. You know what I'm saying? You're driving by. I mean, how good of a look are you really gonna get? So I feel like that one probably. I feel like the thing is with your memory, it can kind of change as things are introduced to you, and that's what I'm worrying about. The state introducing ideas, introducing things, and your memory over years can actually change what you remember, and you can create like these false memories. So I'm a little bit afraid of that. I'm afraid of the state putting things into these witnesses' head, because state knows what they're doing. They have all kinds of tactics and stuff. So they had almost 7 years. Well, by the time this happened, the trial, to like influence their memory, influence their thoughts. It's crazy, but it's going to be hard to trust what they see, and not even that they would be doing it on purpose. You know what I'm saying? Not that they would purposely be lying, but that's what they would be remembering, something that might not be accurate. Because even if like you have a trial a year after, that a lot of those witness testimonies are not very accurate at all. But I still would like to see what Betsy says, like, about, because she was so sure, like, she got a good look at this person really well. So what did she see? Could she say that it's not Keegan? Could she say that it's not Elvis? Like, what is her thoughts? Now, of course, if she's talking to the state and they don't think it's him, then they're not gonna want her to say that, probably. Um, Alan, are you kidding me? They do it all the time. You can influence memories so easily. And you don't think that the state influences their witnesses? Sometimes they like plan it out what everybody's going to say, or they coach them. That happens like all the time. That's what they do. They coach them. And usually it should be, if it's not like corrupt, it should just be to help them, like what they're going to ask, and help them through it. How it's going to be set up. But even like good a good team, like a good prosecutors that aren't like corrupt like these guys are, even them kind of like mold them into a witness that they want. You know what I'm saying? Like, okay, well, that doesn't fit, so it depends as far as how far they go. So no, that happens a lot. Like, and then sometimes they could be doing it and the person doesn't even realize that they're doing it, by the questions they ask and about like going over it and practicing, where they'll end up like kind of like making them almost like create kind of these false memories in a way. They could be real subtle, but the way that they form the questions and the way they like go over and practice, yeah, each time they could like slowly do it. Yeah, I feel like 100%. I feel like even like a honest team does it a little bit to make their case strong and to make sure, they do that kind of stuff. You're not that naive to think that. I would say like every trial does it a little bit, as far as even in general how they tell the jury what happened. Of course, they're going to exaggerate and like tweak little things, lie little things to fit their narrative, because usually it's something where they're not there. You know what I'm saying? They don't have like the whole picture. They're not there for it. So they need to create a story to the jury and make it believable. Yeah, they fill in the blanks. Heck yeah. Heck yeah. I know, but I'm saying you're not understanding it. You're not understanding what I'm saying, I don't think. You're being too like specific. I'm just saying in general. So, you know, whatever route or whatever they're feeding these witnesses, and like how they're questioning them, how they're talking to them with kind of whatever. We don't know how deep it goes, even if it doesn't go that far, but I still think that there's still influences coming the whole time because of everything. I don't know. We don't know. Some people think it's like real deep and it's like from day one. Some people think, maybe not, but I think that there could be a little bit of a mix. You know what I'm saying? Like, I don't know. I haven't decided if it's like the whole time that it was corrupt as far as like this case, or if it's like they didn't have anything. So I don't know. But as far as in general, yeah, they do that crap all the time. It's ridiculous, but that's just the way it is. It's just the way it is. Crystal, what up? Yes, exactly, exactly. And I think it's almost like everybody knows that. It's not like a secret, it's just the way it is. Like, especially now that it's like, the way the technology is now, we see more of them. There's more eyes on trials, and you get to see people are requesting records, and we're able to read things and see their testimonies, compare it to the trial, because we're able to read the trial, either see the trial or read the transcript. So people are becoming even more aware how much it happens. But I mean, it's not a secret, Alan. That happens. Yeah, both sides. Yeah, you're right. You're right. But remember, these witnesses are going to be the state's witness. They're the ones coaching them. So as far as this whole scenario, that's the reason I'm talking about them, is because we're talking about their witnesses and the people they're talking to. So, you know what I'm saying? So what I'm talking about now is related to the prosecution right now and their memories as far as that. So that's, yeah, I know it happens on both sides, but that's why I'm talking about that anyway. Ashley, where are you? What did Anthony just send me?
My phone just turned on. I'm coming in.
I didn't realize I had my screen up, Anthony. Sorry, I didn't realize I had my screen up. Or I didn't realize it was that screen. That's why I hate having Facebook up. What did you send me? I'm not sure. I'll go through it now. Are you ready, Ashley, or no?
No, I'm about to enter StreamYard on my phone, though. Okay. Give me like 2 minutes tops.
Well, here, let's just see what he read. I don't know if this is in one of the things that I have portioned out, but I'm not sure what the point of sending. But let's see, maybe it's something we're talking about. I don't know. Let me see. Well, we're waiting for her. I mean, how did that? Wait a minute. I have my other screen shared. How did that come up? I swear I had this screen shared. That's weird. So this is what he sent. Let's see. The Indiana Public Defender Council mission is to improve legal representation provided at public expense in Indiana state courts. This mission is fulfilled in part by providing research, training, and consultation on a strategy and tactics. IPDC is also mandated to assist the coordination of the duties of the attorneys engaged in the defense of indigents. Well, let me take some water. At public expense. Maintain liaison contact with the study commissions, organizations, agencies of all branches of local, state, federal government that will benefit criminal defense as part of the fair administration of justice of Indiana. They're well positioned to address the importance of independence of defense function, a topic at the core of the work it does. Aligned with the realtor Richard Allen in raising concerns about the removal of his court-appointed counsel. However, this brief intentionally focuses narrowly on independent concerns. The counsel is committed to supporting appointed counsel, whoever they may be, as this case continues. Indiana has long been a leader in providing appointed counsel, and in the recent decades has made strides to preserve counsel's independence from the judges before whom they appear. The removal of appointed counsel for broad or vague reasons undermines the independence of the defense's function and extinguishes a long-standing rapport with a client who must now languish in prison for an additional 9 months. That's what I was just saying. That sucks, because he's the one that has to be in prison for another almost a year. Moreover, after removal of counsel, replacement counsel should have amicus brief of the Indiana Public Defender. Moreover, after removal of counsel, replacement counsel should have, okay. Been selected according to the Carroll County Plan from a list of qualified attorneys approved by the county's Public Defender Board or by referral to the state Public Defender for selection of replacement counsel. Appointing counsel from Allen County, especially the chief public defender of that county, deprives Indiana's third largest county of the leader of its public defender office and raises the prospect of loss of reimbursement for Allen County if commission standards are not met. Argument. This case raises significant concerns about the independence defense of counsel and the public defense structures designed to ensure it. The removal or replacement of appointed counsel must occur in a manner that ensures the independence of defense counsel. IPDC is also concerned that the removal does not undermine the public defender structures in both Carroll and Allen counties. Indiana has been leader in the public defense and the independence of defense counsel. How many pages is this, though? 12. In many ways, Indiana has been a leader in providing representation to those unable to afford counsel. For example, more than a century before Gideon versus Wainwright, this court held that indigent criminals defendants had a right to counsel provided at public expenses. For most of Indiana's history, trial judges appointed counsel and required their compensation from the county treasury. But a deep and persistent concern was the lack of defense counsel's independence from the court, because the defense counsel's appointment relied upon a amicus brief of the Indiana Public Defender Counsel judge. It was thought that counsel might be reluctant to represent his or her client as vigorously as necessary for fear of alienating the judge. Wait, what? Employment relied upon it. The American Bar Association, among other groups, has long emphasized the critical importance of public defender independence. The very first of the ABA's 10 principles of a public defense delivery system, which provides guidance on how to create a well-functioning and constitutionally sound public defense system, is that the public defense function, including the selection, funding, and payment of defense counsel, Independent Indiana Task Force on Public Defense. Under this principle, the public defense function should be independent from political influence and the subject to judicial supervision only in the same manner and to the same extent as retained counsel. So let's see. In 1889, created the Indiana Public Defender Commission, which began a series of reforms to improve indigent defense services. The commission's original mission was to make recommendations concerning providing indigent counsel. So, yeah. As noted in Johnson, trial courts retain some ability to appoint counsel. Trial courts retain some ability to appoint counsel outside of a county's comprehensive plan in limited circumstances. Why am I not? Okay, trial courts. So appointments outside the approved plan may affect the ability to seek reimbursement from the commission. First, under Indiana Code, a judge may appoint counsel outside of the plan when the interests of justice require. A court may also appoint counsel to assist counsels provided for under the board's plan as co-counsel when the interests of justice require. However, expenditures outside the plan are not subject to reimbursement from the Public Defense Fund. Amicus brief of the Indiana subsection provides a better route that protects both independence and reimbursement. Make a written request to the public defender to provide a qualified attorney for the defense of a person charged in the court with a criminal offense and eligible for representation at public expense. If the judge determines that an attorney provided under the county public defender board's plan is not qualified or available to represent the person, or that the interest of justice an attorney other than the attorney provided for by the county defender board plan should be appointed. Yeah, they now provide that the public defender should be subject to judicial authority and review only in the same manner, in the same extent as a retained counsel and the prosecuting agency and its lawyers. IPDC is unaware of the removal of an Indiana prosecutor under circumstances of alleged gross negligence. Public defenders deserve the same treatment as prosecutors by Indiana's trial courts. Counsel was replaced without regard to Carroll County's comprehensive plan. The independence concerns raised by removing appointed counsel are exacerbated when the process for selection of replacement counsel fails to follow the statutes and structures designed to protect the independence of defense counsel. Carroll County is a member of the Public Defenders Commission and it has a public defender board and comprehensive plan. The commissioners of Carroll County adopted an ordinance creating a public defender board in 2000. The county's plan provides an assigned counsel system under this appointment system. The board shall gather and maintain a list of attorneys qualified to represent indigent defenders. Upon the determination by a court that a person is indigent and entitled to legal representation. Okay. So here, it is unclear why the respondent appointed counsel in a manner inconsistent with Carroll County's comprehensive plan. Immediately after announcing that Mr. Baldwin had orally moved to withdraw and that Mr. Rosie would be filing a written motion to withdraw, the respondent stated, I will reach amicus brief of... I keep reading that. That's oh my God. I was wondering why it wasn't making sense. I will reach out to the public defenders to make that appointment. No qualified Carroll County attorney was able to take this case. The preferred procedure would have been for the respondent court to contact the state public defender for selection of replacement counsel. Not only would this allow reimbursement in what will likely be an especially long and expensive proceeding, but it would also better ensure independence by insulating the selection from the control by the judge presiding over the case. Public defense in the Allen County is also affected. Instead, the respondent reached out to and chose 2 lawyers from Allen County, neither of which is on the Carroll County list, and one of whom is currently serving as the chief public defender of Allen County. Thus, in addition to jeopardizing the possibility of reimbursement for Carroll County, the appointment of Mr. Labrado deprives Indiana's 3rd largest county of the leader of its public defender's office and raises the prospect of loss of reimbursement for Allen County if commission standards are not met. Man, see, this is all, like, she's screwed up in many ways. This is not right. I wasn't even aware of this. So Mr. Allen and the public paying for his defense deserve better. As a final point, although this brief focuses on statutes and procedures designed to protect the independence of defense counsel, we should not lose sight of the person most affected. Public defenders do extraordinary, life-changing work every day in courtrooms around the state. Mr. Allen was pleased with the work of his initially appointed public defenders. Mr. Allen and the public that funds his defense should be entitled to more than vague and broad concerns about gross negligence, and that a judge cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. Such statements do not engender confidence in the criminal justice system for criminal defendants, many of whom believe that appointed counsel is not a real lawyer, but a public defender, or a lawyer who works for the state. When followed, the statutes and decisional law outlined above provide some means to dispel these misconceptions. When not followed, the trust and rapport developed during a full year of intensive representation is lost, and Mr. Allen is left to wait 9 additional months incarcerated in the Department of Correction under conditions that he and his counsel of choice have stated undermine his ability to prepare his defense. Conclusion: the issues presented in this case justify the intervention of this court at this stage to preserve the independence of defense counsel and the integrity of the public defense structures established by the General Assembly. The court can uphold these essential values by reinstating Mr. Allen's initial and desired counsel. In the alternative, the court should direct the respondent court to follow Indiana Code section by referring the case to the public defender for selection. Yeah. That's interesting. And so, yeah, I mean, for more than the obvious ways, like, you know what I'm saying? For a lot more ways, like, this is not right. This is not right at all. All right. Ashley, are you back? Or, hold on one second. Okay. Should I remove the other one? I'm going to remove that one. Okay.
I have to leave it up there so I can read still, but because it's small on my phone.
Oh, you have to have that up there, you mean? You can't look. Oh, wait.
Oh, no, I don't have to. Wait. Yeah, I don't have to.
Yeah, I wouldn't think you
I'm
would.
backstage and I can still read it. So we're good.
Okay. All right, so let's do this. Sorry, Anthony just sent that to me, so I was like, oh, I'll just read this.
Yeah, that was interesting too. I was listening. Wow.
It is, because I didn't realize all that other stuff that's not, that she didn't follow.
No, I followed it. Yeah, I can't either. That's crazy.
Okay. You ready?
I'm ready.
All right. Hold on.
I do think I found out the problem though. It's like there's like a delay. Like my phone's quicker than my computer is, and like the sound's like 5 seconds. It takes like 5 seconds to, like, I don't know, for the sound to come through.
On your phone?
On my computer. Like my phone's faster than my computer.
Yeah, see, I told you. Yeah.
It's so weird. I don't know why, but it's like the sound, it's like quicker. Because it seems like it's like that for you, but it works for me fine. Like it sounds okay, like it does with chat, but I don't know, it's weird.
Yeah. It's definitely like a struggle for me, because it's like it's on me, like I could hear it and it's not matching up, but
right.
Okay. So let's do this. Wait, where did I put the freaking? Oh, it's in my. That's right, it's here. Okay, hold on one second. Here we go. Okay. Let me make it bigger. So you're the blue. So go ahead when you're ready.
All right. October?
That's fine, Judge. The state, whatever is fine with the court is fine with the state, Judge.
Mr. Scremin, Mr. Librato?
October would be fine, Your Honor, for a start.
Then why don't we look? October 14th is marked off. What is that?
Columbus Day, Your Honor.
Columbus Day? Thank you, Karen. You may mark that off. So we'll look at October 15th through the 31st. Fine, Judge. And we again would pick the jury in Fort Wayne and bring them here to Carroll County for trial. There's a pending motion to suppress. There is the Franks that is not yet. I haven't finished even reading it or going through all the hours of interviews that were provided on a flash drive. So you'll need a hearing date for that. And once you get the discovery and once you've had the opportunity to review the pleadings, you could either adopt those pleadings or make your own. It's up to you. Anything else from the state?
Judge, we want to create a record to be clear on what you're doing. You're disqualifying Brad and me, is that correct?
Correct.
We would like to be heard through my attorney, David Hennessy.
Sure.
Good morning, Your Honor. I do have a limited appearance on record, which hasn't been removed or disqualified. The court has my preliminary memorandum about disqualification when Mr. Rosie and Mr. Baldwin were appointed counsel. This is yet different. The law that I gave the court is even more certain. The court appears to be saying that it's protecting Mr. Allen, but the court's finding a gross negligence The court's finding of gross negligence was summary, without notice, without the opportunity to be heard. Had you given Mr. Rosie and Mr. Baldwin notice of your intentions on October 19th when they were formed, which seems to be like a week earlier, then they could have been prepared. I can tell you this on behalf of both of these gentlemen. You would have the Indiana Public Defender Council come testify. You would have a competent attorneys from across the state come testify. You would have defense counsel that have been declared experts in criminal defense. Mr. Baldwin's one of a handful of lawyers in the state that's certified in criminal defense. So your summary ruling violates the Constitution, and your summary ruling is unfair to everyone. especially Mr. Allen, because he was never able to make a record. Your finding of gross negligence, what you cited to them in chambers, which was never put on the record, is not gross negligence. It's a zealous representation, maybe too zealous for the court's favor, but it was good lawyering. The memorandum on the Franks issue is a work of art. It's legal writing at its best.
This has nothing to do with the Franks issue, sir.
No, but that...
Nothing to do with that, so please stay.
No, it has to do with your finding of gross negligence, and what I'm citing to the court are the activities.
I never mentioned the Franks.
I'm sorry.
Never mentioned the Franks hearing. Never mentioned the motions, sir.
Okay, you mentioned the transport orders. Unfortunately, the public and I was not allowed in representing Mr. Baldwin. And unfortunately, the public and I aren't privy to the recording of the session outside the presence of Mr. Allen. He has a right to be present at every critical stage of the proceedings. When the court coerces a withdrawal or quitting, that's a critical stage of the proceedings. He wasn't present, and I'd be happy to address each and every point that you think constitutes gross negligence. I've practiced criminal defense for 40 years. I understand and know in detail what these lawyers have done on behalf of Mr. Allen has been nothing but zealous representation. So thank you. I have no expectation you'll change your mind for allowing us to make a more complete record about your findings of gross negligence and disregard for Mr. Allen and unfairness to Mr. Baldwin and unfairness to Mr. Rosie.
Thank you, Mr. Hennessy.
Thank you, Judge.
Anything else from the state?
No, Your Honor.
Mr. Scremin?
No, Your Honor. Thank you.
Mr. Librato?
No, ma'am.
All right. Thank you very much. We've set a trial. We are in recess.
All right. So that's that. Man, good job. Hennessy was on it.
Yeah, he was.
Oh, shoot. All right. Let me
Like, no, Judge. It has to do with that, not the Franks.
He was awesome.
Yeah, he was.
Wait, did I? Oh, yeah, I read that. So let me see what else. So 39. Let's see what 39 is.
Okay.
I just wrote these page numbers so I don't. Okay. Why is that not? Oh, there we go. So 39 is motion for early trial. Oh, this is the motion for early trial. So it says, oh, wait, I want to actually, since you could respond, does it sound better with my microphone up higher or no?
A lot better. Yeah.
Dang it. That was the issue probably like this whole time. Even with my other one, I didn't have it high enough.
Yeah, because I would notice sometimes when you'd pull away, especially on your other mic, like you would just go like a little, like sit back just a little too far and it would cut out sometimes, like the sound would be quieter.
I wonder, they say there's different settings, and the one that's supposed to be for like podcasts and stuff like that. But I wonder, since I move around a lot, if maybe I should put it on a different setting. You know what I'm saying?
Maybe.
But I know it helps because
it's worked great. So
it's like with it being up higher.
Yeah.
Okay. Good. All right. So motion for early trial, and this is Richard Allen. Look, sign Richard Allen. The defendant, Richard M. Allen, by counsel, moves the court for an early trial within 70 days pursuant to Criminal Rule 4B1 of the Indiana Rules of Procedure. Wonder how that's going to work. Now, if he's able to keep his defense, then they should be able to do it then, But what do you think's going to happen? But November, wait, they pushed it to November, 16th or 19th? When was it? Hold on. Where do I have it?
Something like that.
I don't have it. But like for the judgment?
Yeah.
I don't know. I don't have it up, but okay. So that's that. Let me see what else. So now we have, wait, page 13? I didn't do that one. Let me see what 13 is. Oh, this is them requesting. So it comes now, counsel for Andrew. The recording, so they're trying to get the recordings and or transcripts of the two chambers sessions in October 19th, or alternatively to give counsel access to the recordings pursuant to the Access to Court Records Act. More specifically, for purpose of this rule, court record means both case records and court administration records. Case record means any document, information, data, or other item created, collected, received, maintained by a court agency, or clerk of court in connection with a particular case. Who has access under the rule? All persons have access to court records as provided in this rule, except as provided in subsection of this rule. General access rule, a court record is accessible to the public except as provided in Rule 5. Court may manage access to audio and video recordings of the proceedings to the extent appropriate to avoid substantial interference with the resource or normal operation of the court to comply. Okay, let's see. Okay, so let me see. Let me go to the next one. Is what page on the 40? This one here. Wait. Oh, this is another one where they're motion for transcript. Realtor by counsel respectfully requests that this honorable court order that the following transcript be prepared. That the in-chambers proceeding held in October 19th in support thereof, Realtor states the following. Realtor has filed this original action after his trial counsel. Attorneys Andrew Baldwin and Brad Rosie were removed from the case due to the court's belief that the trial counsel engaged in gross negligence. It says attorneys Baldwin and Rosie requested that the in-chambers proceeding be required, and undersigned counsel confirmed that with the court reporter that there is indeed a recording of the proceeding held that day in chambers. So there is. It says it confirmed that there is a recording, right? Is that, yeah. The counsel confirmed with the court reporter there is a recording. Okay. The Indiana Rule procedure for original actions require a realtor to provide the Supreme Court with a relevant transcript of any evidence in the record if it exists. Attorneys Baldwin and Rosie was disqualified as Allen's attorneys at a hearing October 31st. On November 1st, undersigned counsel contacted Jody Williams, the court reporter, by email to make arrangements for preparation of an expedited transcript. She was out of the office, but promptly responded to the client's email. November 2nd, court reporter informed counsel that the hearings held in open court on October 19th, October 31st could be prepared and made available by November 3rd. However, with respect to the in-chambers proceedings, court reporter Williams informed counsel that the in-camera meeting was a meeting of the parties and not a hearing in open court. It is confidential, and I am unable to provide that at this time. Undersigned counsel Kara Weinecke responded that she would prepare and file her limited appearance and written motion for transcripts. As limited appearance counsel in the calls on behalf of Allen, counsel informed the court reporter that attorney Weinecke should be permitted to receive the transcript regardless of its confidential status. Okay, so motion for transcript are on the docket. What does it say? Court reporter Williams informed counsel that she still maintained the in-chambers proceeding was confidential and thus she could not provide a transcript to counsel until the trial court granted the motion. On November 3rd, Mark Lehman traveled to Fort Wayne to obtain the transcript of the hearings held in open court. Before attorney Lehman left Fort Wayne, attorney Weinecke asked court reporter Williams if attorney Lehman should remain in Fort Wayne in the event the trial court ruled on the motion for transcript. In response, court reporter Williamson indicated that counsel could not obtain the transcript that day, even if the court permitted them to have it. It says the trial court has not ruled on the counsel's motion for transcript. Due to the emergent nature of this original action, counsel filed the record proceedings without transcript of the in-chambers proceeding and now asks the court to order the transcript be prepared. Okay, so I want to exit out of that. So, and we read, is this the one we read? Hold on a second. Yeah, okay. Hold on, what's this? I swear there was another one. No, hold on a second. I guess not. Okay, let me exit that. No, I don't need to see that. Okay. So page 214. Okay. How's everybody doing? I'm going to chat with you guys in a minute. This is the last thing I have to read before we could chat a little bit. Okay, I want to make it bigger. So this is this is two. Wait, how far down? Oh, yeah, from from Rosie, October 12th. Dear Judge, in the wake of the recent circumstances surrounding the distribution of crime scene photos in this case, Andrew and I thought it appropriate to communicate to the court in writing our version of the events and general thoughts regarding Nick's comments that he believed disqualification may be the appropriate remedy here. Naturally, those are strong words and warrant some response from the defense. Therefore, we thought it appropriate to provide some context regarding what has occurred here and the circumstances arising therefrom. Our thoughts are as follows. Wait, this is from October 12th. Okay, so let me make it one more bigger and we'll read this. So here's this is the defense's saying how everything happened, okay? All right. So facts. Andy has offices in 3 separate locations, but primarily works out of his Franklin office. In the far back of his office building. Oh, sorry. Let me do this. Andy has a personal office which sits next to his conference room. Throughout this case, we, the defense, has utilized the conference room as our home base in terms of storing diagrams, photographs, and other exhibits that are involved in this case. We have also used the conference room for our defense team meetings and to generally review discovery. This includes searching through the 20 or more hard drives that we have been provided by the state, various thumb drives, and other discovery documentation. I would estimate that 90% of the discovery and related materials in this case are generally located in Andy's office. Andy has a friend by the name of Mitch Westerman. Mitch has a law degree from Valparaiso, and at one point in the past worked as an employee at Andy's firm. Mitch is also Andy's personal friend. It is my understanding that Mitch had a girlfriend in the Franklin area and therefore would routinely stop by the office when he visited his girlfriend. Andy communicated to me that Mitch was a fairly skilled strategist, that he would sometimes communicate ideas and circumstances with Mitch to get his feedback. Hold on one second. Man, why do I get the names mixed up between Andy Baldwin and Brad Rose? I always have to think the first names and who they are. It drives me crazy.
So do I.
Yeah, I always want to mix it up. Not the last names. I got the last names good. Like, I understand who Rosie is and who's Baldwin is.
Right.
But when the first names, it's like I got to do extra thinking.
Yeah, that's with me too.
Yeah, because I know them by their last names. So, okay, let me try to remember them by their first names. Okay, so wait, hold on. Andy is the Rosie, right? No, wait. No, Andy is Baldwin. See, I did it again. Okay, wait. I gotta make some kind of association between Andy and Baldwin and what he looks like. And then Brad Rosie. Why? Because I don't know why I keep thinking Brad's the Baldwin. Okay, so Brad Rosie is the dark haired one. So Brad. I don't know. I can't.
Brad the
right.
brunette.
No, but he's more like, I look at him more like even darker than that, right? Though.
Yeah,
what color hair is?
Kind of guess. It's like black.
Brad the black or Brad Black. Or wait, no, Brad is the other. Wait, I'm confused.
Who is who now? Because now I'm confused.
Hold on. Brad is the dark-haired one. He's the younger one. Andy is Baldwin. Okay. So, Brad Black, because Brad has black hair. It's black or dark. He's got darker hair. I would look at it like it's black, but maybe it's dark brown. But I'm just going to remember.
Yeah.
Brad, right? Brad Black. Andy.
Yeah, Teresa said AB. Andy Baldwin. That's kind of easy to remember. AB.
Okay, but I also need to picture the faces for some reason. I don't know why with this. Because I know the last name's okay, Andy Sandy. He's got the Sandy gray.
That works.
Brad Black, Andy Sandy. Okay, maybe I'll remember that. All right. So Andy, or wait, where are we at? Oh, so yeah, so like Andy likes to, looks like he likes to talk things over with Mitch because he's got like he likes his way of thinking, right? So Andy reported that he did this on occasion in this case. Wait, I have a question here. Where is the line? Like, well, no, because there's a gag order, right? Is Andy allowed to talk to him about this case?
Oh, good question. I don't know.
Is he? Maybe he's allowed, but only for what like the public already knows, and maybe doesn't. He can't like say anything that they wouldn't know. But still, you would think maybe he is he allowed because Andy would know this stuff. So the way he would, even if he just tries to talk about the stuff that's known, and there would already be like he already would know more, so it would probably come out. And like I don't know. That does anybody know? I think maybe normally, but since there's a gag order, you wouldn't think, right?
That's what you'd think, yeah.
Does anybody know that? Yeah, I think with the gag order, I don't think they're allowed. But let's see here. But he's saying that, so where are we at? At no time did Andy ever authorize Mitch. Wait, what was the last sentence? Oh yeah. At no time did Andy ever authorize Mitch to duplicate or take physical possession of any exhibits or documentation in this case. During the week of October 2nd, the defense became aware of a gentleman in Texas who had claimed that crime scene photos had been leaked and that Andy was the party who leaked the photos. Naturally, this called for some immediate disclosure. Andy and I discussed the matter and believed that it was important to communicate our concerns with the prosecutor in court. This disclosure was accomplished throughout the emails you received from us last week. On Monday, October 9th, 2023, Mitch showed up at Andy's office and asked for a few minutes of Andy's time. Andy reports that during the conversation, Mitch acknowledged that he had made a mistake and, in fact, took it upon himself to access Andy's conference room and photograph some exhibits that he discovered laying on the table. We believe this occurred back in August when we were preparing for the first round of depositions. In fact, Nick later confirmed that the prosecution, believes that the docs possessed by Westerman are the same or similar exhibits that were offered up by us during depositions. Westerman then reported to Andy that he shared these images with his military friend who is not associated with the defense in any manner. This man then apparently distributed them to a man in Texas. The man in Texas is the same individual that was accusing Andy of intentionally leaking these documents. Wait a minute. So he knew if the man in Texas, well, I guess he maybe did know. I feel like the man in Texas maybe purposely lied, though, to try to. I don't know what the guy told him that gave him that. So the military friend of Mitch's would have gave this man in Texas these. You know what I'm saying? Obviously, they would probably. I'm sure Mitch was like, "Hey, don't say," because he took them. I'm sure he was like more like, "Hey, don't share these. Don't say this. Like, I just took them from." I'm sure he didn't say like, "Oh, he just gave them to me." I'm sure he said like, "I just took them." So he probably relayed that, right? Maybe, I don't know. I'm assuming, but I wonder if this guy in Texas like purposely tried to like get
set him up
wrong by the defense, like to say, "Oh no, he purposely leaked him," knowing that wasn't true. I don't know.
Could-have.
Wait, Zav laying on the table. How can Snay then say it was from a computer? I don't know. Art of deduction. Hey there, though, buddy. Okay, so where are we at? The man in Texas. Okay, this man apparently distributes the man in Texas. The man in Texas. Okay, so he's saying they intentionally leak in the documents. This was the guy that said that. Okay. Mitch then apologized to Andy for what he had done and indicated that he would do whatever was necessary to make things right, including talking to the police. This conversation between Andy and Mitch occurred around 4 p.m. Monday, October 9th. At 4:48, Andy shared with me what had occurred at his office in Franklin via email. I did not see the email until the morning of October 10th, as I attended a school board meeting on Monday afternoon at 5, and thereafter spent time with my kids the next morning. Wait, who's writing this again? I'm just
I'm
gonna
not sure.
hold on. I'm gonna highlight this so I know where I left off. But I want to see
Yeah.
who's writing this, because he's the one. Oh, Andy is okay. So
Okay.
Andy is sharing it with or wait, Rosie. Andy's sharing it with Rosie. Okay. Or Andy's writing to Rosie. Okay. Or Andy, no, Rosie is the one writing this, but he's the one saying that Andy emailed him what happened. Okay. And then
Right.
he didn't see it till the 10th. Okay. Wow, how far up was this?
Yeah.
What the heck? Wait a minute. Dang it. That's a lot.
Wow.
Where are we? The next morning, Tuesday, October 10th, while at work, I discovered the email. I then immediately communicated with Andy. We agreed that we need to disclose these facts to Nick immediately, which we did. See, they took all the proper necessary steps, right? They found out about the leak. They freaking told Nick. And the judge, we saw that they emailed the judge too. So I mean, I don't think they should be disqualified for this at all. That's ridiculous. And the judge claims it has nothing to do with the Frank's memorandum. We saw that. That's not why they're being disqualified. It's this.
Exactly.
How do you blame them for somebody going into their office and basically stealing something? Like, how, I don't understand how you're going to disqualify them and then like hurt Richard for that. Richard's the one that's going to hurt the most, right?
Yeah. It's sad.
Yeah, there's no, I don't feel like they should have been disqualified.
Me
Not
either.
at all. Where are we at? So this occurred by the way of a phone call with Nick just minutes before we spoke with you yesterday. As a follow-up matter, who is that? Wait. Who this? Oh, this was addressed to Gall, right? So he's saying right after we talked to Nick, we told the judge, we told you. Okay. As a follow-up matter, we have tried to encourage Mr. Westerman to make himself available to the police for questioning either alone or through a lawyer. We've learned he has sought out legal representation. We spoke with his attorney, who refrained from any substantive comment regarding the matter. The same attorney then communicated to us a few hours later that he was getting out of the matter and was referring Mr. Westerman to alternative counsel. Understanding that there are some obvious barriers here, we are attempting to try and convince Mr. Westerman that he should come forward and acknowledge his wrongdoing. Wonder what that charge would be.
Yeah, me too. Would it be
Anybody know?
impeding on an investigation since they leaked it and the trial hasn't happened yet?
Maybe. I don't know. I have no idea. Does anybody else know? Maybe it could be. It could be probably a couple charges, huh?
Yeah, that's what I was thinking.
It is also, wait, let me make sure. Yeah. It is also worth knowing, worth nothing. Or is it note? I mean, where is that supposed to be noting? I don't know. That Attorney Rosie, have made arrangements to provide a formal statement to Trooper Ben Rector today, October 12th, at the State Police Post in Peru. Attorney Baldwin has also reached out to Trooper Rector to make arrangements to make a statement regarding the matter. He currently awaits the trooper's phone call. I have disclosed the issue to Mr. Allen himself and communicated various matters involving the case to Mr. Allen. Mr. Allen communicated to me that he desired that we, Baldwin and myself, continue with our representation of him. I have included herewith a letter confirming this fact. These are the facts as I understand them at this time. What occurred here? Our analysis of the situation is that Mitch Westerman committed a crime by exerting unauthorized control over the property of another with intent to deprive the other person, Andy Baldwin, of any part of its value or use. This is theft. Mr. Westerman's criminal acts were then aggravated by his further distribution of the stolen images. Well, yeah, theft. I wonder if that would be the most obvious, is the theft, but I feel like it's going to be more because of the case. You know what I'm saying? Of what it was. Yeah. But yeah, that's like I said, freaking blaming the victim of a robbery of some, you know what I'm saying, of something that, let's say they steal something and they do something with those whatever they steal, and then blaming that person. Let's say, oh, they steal a gun and then kill somebody, and then blaming the person they stole it from. I don't know if that's a good example, but it's, it's just, you can't do that.
It's close enough. Yeah, that's a good
Yeah.
example.
Yeah. What occurred here? Or did I already read that? Yeah. Is this a violation of the gag order? No, because freaking he didn't do it. Anyway, the order on judgment of the court, gag order dated December 1st, 2022, prohibits the parties from disseminating information or releasing any judicial statements by means of public communication. In this circumstance, Mr. Westerman engaged in the criminal act of theft and thereafter took it upon himself to further distribute the stolen images. At no time did anyone from the defense team ever disseminate information by means of public communication, i.e. the media. In fact, there was never any specific intent on the part of the defense to disseminate the information in any manner. This does not amount to a violation of the gag order. Have the rules of professional conduct been violated? A lawyer must act confidently to safeguard information relating to the representation of a client against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in representation of the client or who are subject to the lawyer's supervision. Again, in this case, we have an individual who committed a criminal act. As a general rule, our approach of marshaling all of the discovery and exhibits arising therefrom in the back of Franklin office demonstrates reasonable care. I guess it's arguable that there may be some semblance of negligence to the extent Mr. Westerman was left alone in the back of the office. Either way, I don't see that there is an intentional act that rose to the level of a violation of the rules of professional conduct. I want to know the specifics of how did he get back there? Did somebody did somebody let him back there and then not making sure the stuff was... did the person that let him back there know that stuff was out? Or did he just wander back there? I have to read his affidavit's so short. He said he was waiting to talk to him. But then how did he get to the spot where the stuff was? You know what I'm saying?
Right. That's what I'm wondering myself. It doesn't seem like he just stumbled upon it, in my opinion,
But here's the thing. If it was like a secretary or somebody that didn't realize that they had that stuff out and this yeah, go wait in the office. No, then it's not their fault. Now, if it was Mr. Baldwin and he just forgot, because not even if he didn't do it on purpose, that would be kind of gross negligence. I see how they could argue it, I guess.
Yeah, but
not being making sure if he put him back there waiting, not making sure that there wasn't evidence. But it doesn't sound like it, because it sounds like he was with somebody else at the time. So it doesn't sound like Mr. Baldwin is the one that knew, that put him back there, or however he got back there, which would make it out of his, no, I don't think he had no, blame in that, if that's the case, which it doesn't sound like it. It sounds like either this guy, Westerman, just kind of took it upon himself, or did somebody, the secretary or somebody, let him back there. Does anybody know? Yeah, he just walked in. But what I'm saying, Art, is how did he get to the room? Because usually there's a lobby, right? You don't just walk into the office. So you're saying he walks in the building and then he just takes it upon himself to oh, Andy's busy, so he just kind of took it upon himself and went into the office. Then 100% it's not freaking Baldwin's fault.
Agreed.
No way. Okay, so where are we at? We're here. Is disqualification appropriate? Our client, Richard Allen, has a Sixth Amendment right to counsel of his choice. If the government moves to disqualify defense counsel, the burden is on the government to show that any infringement on the defendant, Allen's choice of counsel, is justified. The burden is on the government to show any infringement on defendant Allen's choice. Yeah, is justified. Exactly. Yep. At the time, has long been recognized that trial courts do have the power to punish misconduct of attorneys and others. To the extent that a court would resort to the extreme remedy of disqualifying a lawyer, nearly all of these circumstances involve the lawyer engaging in some conflict of interest. Rule 1.7 through 111 generally addresses conflict of interest. None of these rules are even applicable in this circumstance. The rules are designed to provide guidance to lawyers and to provide structure for regulating conduct through disciplinary agencies. The mere fact that a rule is just a basis for a lawyer's self-assessment or for sanctioning a lawyer under the administration of a disciplinary authority does not imply that an adversarial party that the prosecutor has standing to seek enforcement of the rule. Any violations of the rule should be brought to the attention of the disciplinary committee, who would then process the allegations in the normal course of business. Simply put, the rules are not intended to be used as weapons to seek disqualification or tactical or other similar reasons. I really do think that the judge kind of got scared because she saw that, wow, they actually have a good defense. Like, they possibly could win this case. You know, like all of like the media, all of the public, like seeing this and reacting like we are and seeing like, oh dang, like, do you think that's a possibility? And then she is like, so that'd be like she's biased, like that she thinks that he did it or doesn't want that as to be the outcome, maybe. I mean, that's just an opinion. There's no way to prove that, but like it almost seems like that it could be.
Right. That's what I think too. It seems like she was worried that, you know, in her mind, he would he'd be found guilty or not guilty. And in her mind, he's just guilty. That's just what it seems like. Just by the way she's treated him. You know, even the way she talks, she comes off as very biased.
Yeah, I agree. Do you want to read some? You want to read a couple into 6 or 7? Can you read it? Okay, go ahead.
I'm down. What part are we on right now? Just 6. Where it's at?
Yeah, 6.
Oh, hang on. It was on the YouTube studio instead of StreamYard. There we go. Did the defense team demonstrate candor to the tribunal? The record is clear that the defense team, upon learning of the information leak, reported this immediately to the court and to the prosecutor. This was done by way of email communications and phone conferences. This conduct is consistent with a lawyer's responsibilities, all of which are referenced in the preamble to the rules of professional conduct. What are the possible sanctions? To the extent there exists some violation of a court order that rises to the level of indirect contempt, an allegation must be brought. None exists in this case because there was no discrimination of information by means of public communication, which is prohibited by the gag order. At worst, this circumstance amounts to a breach of the defense's duty to maintain confidentiality of information. Sorry, it keeps disappearing for me. Pursuant to Rule 1.6 and or a breach of the defense's obligation to safekeep property pursuant to Rule 1.15. We believe it is neither as the acts leading to the dissemination of property. We're not intentional or even reckless. To the extent the prosecutor believes that there is wrongdoing on our part, the matter should be raised, though the disciplinary purposes. Their process, sorry. What are the practical circumstances created by this issue? First, the only photograph that appears to have been disseminated amongst the public is that one of the F tree. The photograph in and of itself is not overly gruesome. There was no evidence to suggest that the crime scene photographs of the two girls have been distributed to the general public. To the extent they are distributed, the information has already been consumed by the public as if it was specifically detailed in the defendant's recent Frank's memorandum filed with the court. Moreover, in the natural course of the litigation, there is an expectation of these images will be displayed in the courtroom at a forthcoming suppression hearing. And at the trial in this cause. All of those matters are scheduled to occur within the next 3 months. Naturally, the defense's most significant concern is that the victim's family members not be forced to endure the stress and violation of privacy that would come with the widespread dissemination of this information. Unfortunately, the exposure of these images is imminent, and the part of the unfortunate side of the legal process in cases of this nature. The defense has nothing to gain by deliberately disseminating this information to the public. In fact, the opposite is true. The likelihood of public backlash is significant and serves no legitimate purpose to Mr. Allen's defense. What are the practical implications of disqualification? As been previously reported to the court, the discovery in this case involves tens of thousands of tips, hundreds of thousands of pages of documents, thousands upon thousands of hours of video, and the engagement of various experts in different disciplines to address a multitude of evidentiary issues. The defense has been working feverishly over the past year to obtain, consume, and understand all of this information. The defense team has engaged in numerous depositions. Various pleadings have been filed with the court. These pleadings contain work product that has resulted from the thousands of hours spent by the defense team in preparing Mr. Allen's defense. It is entirely impractical to even consider the prospect of disqualifying either one or both of us. It would be nearly impossible for successor attorneys to effectively engage in such a massive endeavor in familiarizing themselves with the discovery and thereafter adapting the work product and theories of the current defense team and thereafter moving forward with an effective representation of Mr. Allen. We need to see the forest for the trees here. There is no doubt that the breach of security warranted immediate attention and necessitates some action to try and stop the further dissemination of the materials. However, this breach simply does not rise to the level of disqualification, which would naturally unduly delay the administration of justice for Mr. Allen and the victims' families. And context for the court. Again, both Andy and I accept responsibility for this lapse in security. It is, however, important that the court have a better understanding of the totality of sensitive information that is in the hands of the public. We do not view this as a tit-for-tat circumstance, but I do think the court needs some general understanding of the amount of information that we believe has been previously disseminated by law enforcement officials. Naturally, it is almost impossible to regulate the disclosure of sensitive information unless there is some direct evidence that it is occurring by the way of statements to the media, which are then shared with the public. However, in order to bring you some context, I'm asking the court to spend 5 minutes watching a portion of the video associated with the following link. This link will also be emailed attached in a separate filing with correspondence, as I don't expect you will be able to access the link in this letter due to formatting issues. This is a segment from a court TV broadcast wherein reporter Barbara McDonald communicates with the host information regarding the sticks that were placed near the girls' bodies at the time of the crime. I would encourage you to watch the portion that begins at about the 10-minute mark and concludes at the 14:30 mark. During this segment, you will see Ms. McDonald articulate that sources close to the investigation have provided me with drawings of what they say these images look like. She further reports that she has spoken to many investigators who were on the scene at the time who say the assumption was the sticks, were randomly placed. She then goes on to share with the host the actual stick formations she claims were provided to her by individuals close to the investigations. I can tell you.
Are you getting tired? Do you want, when you get down to this paragraph, you want me to continue or no?
Yeah, that's cool.
Okay,
I can tell you that these formations are the same formations that were contained in the missing Purdue report that was generated by the state's consultant on Odinism. We recently filed pleadings articulating that this report was handed to us a few weeks back. It seems obvious that portions of the report were shared with the media at some point in the past. Ms. McDonald was also aware that the sticks were not immediately secured as evidence by law enforcement authorities, a fact that could only be learned by reading the incident reports or speaking with investigators.
I wonder what, I tried to click on that when I had to oh, am I on mute? No. And wonder what that video was. Like,
I do wonder too. I wonder if you can like type it into your search browser.
I know, I'm gonna try. Yeah, sometimes you can, sometimes you can't, sometimes you can't. It depends. A lot of the times when that's happened, like when I've typed it in, the video will be removed in those circumstances. But we'll see. I'm gonna definitely try. Okay, so the point here is not to debate the relevance and significance of the stick formations. The point is to demonstrate to the court that there has been, throughout this entire investigation, sensitive information provided by law enforcement investigators to the mainstream media. Frankly, the defense doesn't have the time nor the resources to police these breaches of discovery to the media. It is a natural part of the landscape with this high-profile case. We are simply trying to make the point that members of the general public in the mainstream media have their hands of various sensitive materials involved associated with this case, and it's virtually impossible to manage the dissemination of this information without incident. Finally, to the extent these photographs are actually published in a widespread manner, this would not in any way prejudice the state's ability to prosecute Mr. Allen, nor prejudice Mr. Allen's ability to defend himself. Again, we are hopeful that this doesn't occur because of the impact on the victims' families, but to the extent it does occur, it would not result in any prejudicial impact to either party. In sum, this is an unfortunate circumstance which does not require some remediation to try and preserve the dignity of the victims, which does require. It is not a basis to disqualify either Andy and or myself at this juncture in the proceedings. Obviously, to the extent you would like supporting law, I would be more than happy to offer up the same. The intent here is simply to communicate in writing our position with regard to the circumstances to try and bring some context to the situation so we can engage in some effective mitigation, the breach, and move forward with the orderly and efficient disposition of this case in January. And see, I agree. I don't think that this it ruins the case on either side. It's more for, for the families that does suck. But for as far as like, you know what I'm saying? And here's the thing. Yeah. Depending on how they're gonna do this trial, if they're gonna release those in trial anyway, then the families are gonna go through it anyway. You know what I'm saying? Regardless. So, I don't know. I doubt with how private they are, it'll probably be one of those things that it is sealed. But you know what I'm saying? I mean, that happens. It's a part of the cases. It does. You know what I'm saying? The crime scene photos, autopsy photos, yes, they are a part of it. So, but here's the thing. I don't think it affects like the defense, like they're saying. I don't affect the defense or the state. I don't think it doesn't affect, because how is that going to make it unfair on one way? How? What is it? Can somebody explain? How would that screw up? You know what I'm saying? How would it make the defense have a better case, or the state a better case with somebody seeing the crime scene photos? The ones that are out, there's only like 4. You know what I'm saying? It's not like how would that? Can somebody explain? Because maybe it would, and I'm missing something, but.
Yeah, I don't know myself. It doesn't make much sense to me as to how that could even affect it. I mean, it's not like they're going to taint the jury or anything. I mean, I guess they could. I guess it could spread so much.
Oh, wait a minute. I guess, okay, here's maybe a possibility. if it did become widespread before the trial and a bunch of people saw it and some of the jury members, it just became so spread that you can't even find a jury that's at least one of them hasn't seen it.
Right, they won't be able to be partial because they saw it, maybe.
But wait. I take that back. Never mind, because that's usually a part of the case. They're going to see it in the trial anyway. Never mind.
Right.
I was like going to like
before the case, I think.
Yeah, but I was going more to the argument. I was thinking, oh, it's going to make them like have more like emotional to it. But no, because it's going to be a part of what they see. So yeah, I don't see how it's going to affect anything.
Yeah, me either.
Hey, Sean. Oh, I'm a shorty. I'm only 5'2".
Me too.
How tall do you think I am?
You do give like a taller than me vibe, at least. I feel like you look like you're like 5'5".
Really?
Yeah, I don't know why, but probably just because I expect everyone to be taller than me.
Yeah, I see. So wait, you're 5'2" too?
Yeah.
See, I would feel like you're more 5'5". Yeah.
That's funny. I used to be 5'3", but for some reason over the last 10 years of my life, I've shrank an inch.
Really?
Yeah, I don't know why.
Shrinking already. Usually, like when you get like really old, you shrink. Yeah. But wait, I want to read this. Okay, the girl, zavgirl, the photos only hurt prosecution and law enforcement because they both lied in sworn affidavits. It appears to help defense. Well, yeah, but see, it's only helping them because of their dishonesty. So you can't argue that because that's just them. Because if they lied, that's just them being dishonest. So yeah, it might hurt them, but not in a way where it's unfair. You know what I'm saying? Because if they lied about it, then you know what I'm saying. But here's the thing: that's gonna be a part of the trial. Everybody's gonna see them at trial. So it's not like it's gonna be like, ooh, people saw things that that nobody is supposed to see ever. And it's not
unless they didn't publish them as evidence, which they kind of have to.
Oh yeah, at least I don't know if they'll make it public, but for the trial, I would, yeah, because the defense. I mean, well, if Rosie and Baldwin were the defense, they for sure were going to use it as a part of their defense, so they 100% would be in it. But I don't know if Lobrato and them. I don't see how you could. I don't know. I don't see how you. Well, I guess it depends the route. So maybe the state wasn't going to use them, but I think they would, even to bring some kind of emotion to the jury. You just see, you know what I'm saying, to get them to feel feel something, because, and maybe hopefully it would help them for, to convict Alan. But yeah, no, you're right, sweet dude. I mean, yeah, you're right, but that's only fair, right? And like I said, Rosie and Baldwin would 100% have used that because they would need it for their defense of what they're saying. Like, a lot of it has to do with that.
True.
To show that, wait a minute, look at this. This is the Odinist, they would have to. So yeah, I don't see how did that do anything? Like, no, how is that going to influence the trial? I don't think it will.
I don't know.
At all. Because it's going to be a part of it. Now, if the discovery, if like the whole discovery was leaked or parts of it, I could see it, because how there's certain things that they're not allowed to show everything. There's certain things off the record, and you know how that goes. So if the whole thing was, then yeah, that would be an issue. But what was leaked, that's going to be a part of it, and it's not even anything where somebody's gonna have, even if there's a discovery that they are gonna show, right? But because they saw it early, and then they have time to the jury would have time to look it up and look up, you know what I'm saying, somebody, potential jurors, but they're supposed to be honest and say what they've seen and what they haven't, and they wouldn't pick those people. But who knows? I know people sometimes would probably lie, but so yeah, I don't. Either way, though, I don't see how it would be big influence if it's something they're going to see anyway. But I guess if they have a chance to look it up or look into something, and you're not supposed to, when you're at the trial, you're only allowed to see certain things. You know what I'm saying? You can't see the news, you can't, So I guess, wait a minute. Okay, so now I'm looking at like that. I guess if it did get out to like mainstream media and then people were commenting, giving their opinions on it, they would be able to influence what the future jurors are going to think of everything,
Yeah,
possibly.
that's what I was kind of trying to say.
But they're supposed to be honest, and when they try to pick the jurors, they would. But I guess if it was so widespread, it'd be hard to find somebody that didn't. I don't know. I still don't think it is, but the bottom line is they got stolen, right?
Yeah. Which sucks, man. I mean, I don't know. I feel bad for the whole case. Why somebody would even leak that is just like that kind of sensitive information just baffles me.
Wait, he's saying, wait, photos were leaked in December.
Yeah, I've seen where
But
like
I
apparently
thought the December thing was the whole Woodhouse. Isn't that when his email was December 22, I thought. Well, how do you know that it was actual photos? That was a newer thing that I've heard. Then it
I
came
do
from the
remember a
email.
while
I mean, we know
ago.
the email, whatever. I think you're thinking of the email, right?
Well, I do remember a while ago there was like a fake photo hoax, but I don't know if that's what he's talking about or what. But I do remember there was like a hoax a few years ago.
Oh, wait. I have the court TV thing. Did we read that? Hold on. Did we read anything about that yet?
I don't think we did.
Yeah, hold on. Thank you for reminding me. There's a document that talks about that I wanted to read. I gotta find it. Hold on. Because it talks about how, wait, court. But that was after still, though. That was after we heard about the leak, I thought. Wasn't it, sweet dude? I thought that was recently though. Remember, that wasn't 2022. That was recently when that court TV. And here's the thing: they got it wrong. And here's the thing: the document that I read, because I remember I skimmed it. So what? Maybe I'm gonna read it, and maybe I misunderstood it. But from like reading it and just kind of skimming through it, I was under the impression that they were insinuating that it looked like that leak came from the state. That if whoever that the source was from court TV sounded like that they were saying that they had inside information from maybe somebody from the state. That was
Right.
December? I thought that was the video I saw. Wasn't that just like a month? That wasn't in December. I've always thought that when that court TV video was like, what, like a month? Or remember when that came out and we're like, then it ended up being wrong?
Yeah, I do because we went
That
over
wasn't
it here.
last year. Unless if I just thought it was a newer video and it wasn't, but I was pretty sure that wasn't last year. But let me find that document because maybe it's in the document. Yeah, I mean, but that's what the state or the defense says it was an outline or whatever, but maybe I don't know, because Woodrow or Woodhouse said it was like the whole thing. So I don't know. Who knows? Who knows? Wait, you're talking about the F. Why did I think that was newer? But anyway, that whole thing, they think that came from the state anyway. I thought the source that the court TV had was the state. And I feel like they weren't accurate anyway. Like I don't even feel like that was even accurate to what the picture looked like to me, unless if they saw something else somewhere. Didn't look like it to me. When I actually saw the real F, I was like, that dude, what? That doesn't even look like how they had the diagram. No, I know the leak was in 23. I know that. Oh, you're saying you don't believe the leak was in 23?
Oh, interesting.
But you're saying Mitch is just going to take blame for something he didn't do? That's like illegal. So maybe there was
Oh,
two
yeah,
leaks
true.
because why would he and he's not even talking to him now, he's an attorney. Like, why would there be two, or why would he do that? So maybe there's two leaks because I do believe he probably he leaked that. I bet you the girls' pictures and the other ones came before. I think the actual pictures of the Libby and Abby, those are from 23, right? Maybe the F and the pictures of the clothes in the lake, maybe that was before. Maybe that one came from Woodhouse. Maybe. Because think about it. He said he got it December 2023. 22, I mean, Woodhouse, that's when he got the email. I'm pretty sure is when he says December 2022. If you're saying that that's when it is, he probably showed somebody, right? And maybe he didn't have the girls' pictures or he just didn't share that with anybody if he did get the whole thing. And I know, Brian, I know that the defense is saying it was just like an outline or whatever, but Woodhouse is saying he got the whole thing. And think about it. December 2022, if that's what you're saying, that's when he got that email. So maybe he did get everything, guys, or maybe he got a lot.
Yeah, maybe, for real.
Well, sweet dude, I never heard anybody had a picture of the girls before recently. So where are you getting that?
Yeah, me either, except for the hoax that was a few years ago.
Oh, I mean, I believe that the pictures of the clothes, because that actually was on Facebook groups. Those were on Facebook groups from a while ago, like the pictures of the the shirt and the shoes. The F I just saw more recently, but maybe that came with all those. So no, I think it was Woodhouse. I think he probably showed somebody back in December 22. That's what I would guess. I mean, who else? Or the state. Let me find that document because they are insinuating that maybe the state actually. I must have forgot to read something. Hold on, let me find. I have more. I think I have more stuff. Let me find it. Are you sure that we didn't already read that, Ashley? On that one you were reading, or no? Because I was kind of like looking in a group, so I wasn't. Are you sure that's not what you read?
It might have been, yeah.
It was Court TV. Oh, so now I'm sounding like an idiot because we just read it. So when she was reading, I was like looking through and seeing if I could find anything. So I didn't. I thought it.
Yeah. Well, I don't know for sure. It could have been though.
Let me see. Hold on. Let me see. Maybe I don't know either. I know I read it somewhere. And it was one of the ones I wanted to share, but we haven't got to it yet. So that's why I'm wondering if you read it because I wasn't paying attention when you were reading because I was trying to look for something else. Hold on, let me see. Defense, Mr. Allen. McDonald's. Give me 1 second, guys. Has anybody listening to us read? Did she already read about it? Does anybody know? Yeah, it is. You read. You read
the
it.
link. Was that part? I wasn't for sure if that's what we were talking about right now or not.
Well, it says the segment from a Court TV broadcast.
Okay, so that was the same video. Okay, yeah. All right.
Oh, that was the video. We were like, what video? Because I'm sorry, I wasn't listening when you were reading because I was doing the Facebook, but I had skimmed the part about Court TV. And then when sorry. So that part. So, okay, Barbara McDonald communicates with the host information regarding the sticks that were placed near the girls' bodies at the time. Wait, do they talk about the F though? Because that's the one I'm talking about. Well, they do the sticks too, but did she do the F too? Hold on. Wait, this is the F part's not even in this part when they're talking about that? Why wouldn't they bring that up? Because that was a thing too that she went over. What?
I'll be right back.
Okay. She further reports that she had spoken to many investigators who were on the scene at the time who say that the assumption was the sticks were randomly placed. She then goes on to share with the host the actual stick formations she claims were provided to her by individuals close to the investigation. I can tell you that these formations are the same formations that were contained in the missing Purdue report that was generated by the state consultant on Odinism. So, Miss McDonald also was aware that the sticks were not immediately secured as evidence by law enforcement authorities, a fact that could only be learned by reading the incident reports or speaking with investigators. To the point here is not to debate the relevance and significance of the stick formations. The point is to demonstrate the court that there has been, throughout this entire investigation, sensitive information provided by the law enforcement. I read this part to the investigation, to the mainstream media. Frankly, the defense doesn't have the time nor the resources to police these breaches of discovery to the media. So yeah, but as far as the girls, I didn't know that was out last year. Gosh, everybody kept it quiet. If you're talking about the pictures of Abby and Libby, you're saying were leaked a year ago, and nobody freaking spread them, and we only heard about them like a month ago. I don't know if I believe that they were. Now the pictures of the clothes and the F and stuff like that. Now I'm not saying nobody got them, of course. You know how that is. It's like, hey, let me share this. Hey, let me share. But I'm talking about where it became like more of a wider spread type thing. But I like, as far as like somebody having a source that shows them or tells them, yeah, I feel like that definitely could happen, and it looks like it's happened, because that's 7 years of like having this information. You'd be silly to think that it didn't get out a little bit to people, that new people have sources. Yeah, that's not surprising to me. But as far as like the issue of the whole thing, but that kind of sucks though, because this kind of got contained and it was only like a few people, but it did spread a little bit further. But if this has been going on this whole time, and the state even has had maybe possibility of sharing it with somebody, maybe that, oh, like I have a source, I trust this person, then why should the defense be the only people punished? You know what I'm saying? That's not fair. I know, I seen that, sweet dude. You guys are like, you're confusing me, because I have one person saying, oh, it's, no, this has happened a long time ago. Then I have some people saying, oh, it's recent. I know, I seen the court TV video. Oh, that's what you're saying. So yeah, the court TV video was new then. Okay. Yeah, so dude, I'm telling you, I think Woodhouse or the investigators, but that's not Baldwin or Rosie though. Because it can't be. They just took on the case. I don't know what you're trying to say, sweet dude. You're confusing me. I'm not arguing about, but like, it's not like, I'm talking about Bradley. Oh my God, I can't even think. Baldwin and Rosie. It can't be Baldwin and Rosie for that. So you're just going along with that document, right? In the court TV. So the court TV was a recent video? Because you were making me think that I'm like so confused here. Dang it. I almost want to delete this live, because this is why it's hard sometimes when we have different people in here saying different things, because like that are saying opposite things.
Right.
Like Teresa saying, no, it's recent. And then, so sweet dude, I was totally confused, but he's saying that the person said in December. So I think the video is recent.
Gotcha.
So I was gonna say, I'm pretty sure that was a new video, like not new now, but it wasn't like last year that they put it out.
Yeah, I remember when we
like,
covered
God,
it.
You're making me think that I'm like crazy or something. So yeah, but I think that source either came from Woodhouse or the state. If her source, maybe she knew Woodhouse or somebody Woodhouse, or it was the investigators. But it's obviously not Brad. It's Baldwin and Rosie, because they just took on the case in 2022. So yeah. Okay, Brian, good. But I feel like, here's the thing. I feel like people are both saying it as facts. You know what I'm saying? So if you're saying two different, one person saying this, no, it's this and this, it's kind of hard for me, because like if I say, oh yeah, and then the other person say no, and then how do I do this? You know what I'm saying? And sweet dude just keeps saying no. So I don't know. Yeah, I don't know. I don't know. I'm just going by what I know right now. And I don't like, so this is all just like thoughts. This is all theories. Okay. So yeah, I don't know. Well, I guess we'll figure out. Maybe we'll never know who's lying, but maybe, yeah. I wouldn't put it past, so can you send me some stuff on Mark? Because I've been asking if anybody knows anything about Mark, and nobody's like sent me anything. So you know who Mark is. Do you have any information on Mark? Because I've been trying to look more into Mark. I mentioned it on like a couple weeks ago, and I said, does anybody know Mark? Like any more about Mark? Because I want to learn about Mark. So if you know some more stuff about Mark, can you send it to me? Thank you. I seen the court TV video though. I just missed the point. So you're saying I don't need to watch it again, but you're saying I missed that point. Okay, so he said it was leaked in 2022. Okay, so I got that. But I still think it could be Woodhouse. And that's fine, Brian. That doesn't surprise me if Woodhouse is included in the gag order. But I think of course he would be, because they knew that he sent the stuff, or he was sent the stuff. So yeah, that would make sense that they'd be like, ooh. But what I'm saying is, are we sure that it wasn't Woodhouse that you're talking about, sweet dude? Is what I'm trying to say. And maybe, here's the thing, sweet dude, maybe the person who somehow got it and then sent it to Murder Sheets was Mark. Or Robert, you know what I'm saying? Are you sure? Because I have a trouble believing that Mitch would just make up a lie and be possibly charged with the freaking crime, though. Are you saying that Mitch is lying then? And taking blame for something? Or could there just be two leaks? Because you think, who's going to just take the blame for a crime, though? Teresa, send me the interview, will you? Oh, wait, I think hold on. That might be the one I did. There was something about that I feel like where it wasn't, hold on. Well, send it to me. That's ringing a bell, and I can't remember why. As far as like coming across that, and then for some reason it wasn't something that was that interesting, maybe. I don't know. Send it to me, though. But why, dude? So, okay, if Mitch took the blame, then who is he covering for? I don't, what would be the point of that? I feel like there's just two leaks. I feel like that there was that leak and then the one from, maybe earlier. And I still think the 2022 is Woodhouse. You don't think it's Woodhouse from 2022? Because didn't he say December 2022 is when he got the email? So that's, I feel like that almost makes perfect sense. But why would he cover for Woodhouse, though? I tried to, Brian. I was going to, but when I just played a video and freaking tried to talk about him the last live, everybody's like, most of the people that were at least chatting were like, oh, this guy's full of it. Why are we watching this guy? It's irrelevant. So it was like, well, I thought it was really relevant, but everybody else was really complaining about it. But I will. Were you there at that live? No, everybody was just like being so weird about it. Like, why are we watching this? I don't understand. What's this about? This is irrelevant. This guy's lying. He's full of it. What's the point? I thought it was. So I kind of like laid off of him for a minute. But yeah, I'll look into him more. Hopefully I won't get any like hopefully people will be into it and not so like against me even thinking it's relevant, because I think he's like very important in this case now, because he was made important because he got sent. I'm sorry, I think he was sent. I believe almost, I'm leaning more towards believing him as far as him being sent more than what the defense is saying they sent him. But I could be wrong. I think he was sent everything for some reason. And maybe that is where you're saying the source from Court TV got their stuff. But yeah, no, I think maybe. Well, no, yeah, Teresa, I don't want to call the people trolls that were doing it. It was just like even a lot of the regular people, they're just like confused on who it was, and then I wouldn't say trolls. Now I feel bad. I was the way I was mocking them. It wasn't trolls. It was just people that were just like they're like he's full of it. He's lying. It was just their opinion. People that strongly opinionated and not as open-minded and open to learn other aspects, which is fine. A lot of people, most people, I would say more people are more closed-minded than open-minded. That's why it's like I love when I find like a truly open-minded person that's willing to change their opinion. You know what I'm saying? Like once they learn more information, and it doesn't just be like because they were so stuck on something that they just like change everything to meet that, even if they're learning more information. And that, I feel like that's more common in people than people like, I don't know. Hopefully I come across, or hopefully your opinion on me, I feel like I'm more like open to that. I feel like I try to strive to be that way, and I feel like I've changed my opinion a lot of times after I've learned new information. Like I've done like 180s before, after I learned stuff, but there's some people that are not willing, even if it's clear as day, but they were so stuck on something that they can't change no matter what. And they just make excuses. You know what I'm saying? So, and that's fine. Like I said, a lot of people are like that. But so no, they definitely weren't trolls. So, but I try to like find a nice balance of what I want to talk about compared to like what you guys want to talk about, and kind of like I don't necessarily let you guys control what I want to talk about, but I have to in a way because you're my viewers, so I have to kind of like find like a nice balance of what the majority kind of is into, because if not, then what's the point? Yeah, personally or privately I could look into stuff, but for the shows that I'm like talking to you guys, I have to find like a nice balance. And I know like there's some people that want to learn this, some people that want to learn this, so you don't have, everybody doesn't want the same thing, but I try to find like the best balance of what people want. And I'm telling you, when I talked about Woodhouse, there was a lot more people that I felt, at least people that chatted. Here's the thing. There's more people watching that don't chat than the chatters. If you look at like the people that are chatting, how many, it's usually, well, now since I barely get any viewers, it's different. But when I used to get a lot of viewers, like you'll see like, a few hundred of people compared to like only like maybe 20 or 30 people chatting. So there's more people actually watching than chatting. But I only see the people chatting, so that's kind of how I form my opinions on what's what, so, which I probably shouldn't, I guess, because, yeah, because usually there is more, so, yeah, I don't know. I try to do the best I can, but it's definitely not trolls that I'm talking about. But no, you're fine, Teresa. I'm not even mad you said that. I mean, you were just meant well, but, I don't know. I try my best to do that, but sometimes I'm better at it. Some days I'm better, some days anyway, okay, so but wait, why would Robert unalive himself if he had nothing to do with it? I thought that was really weighing on him. See, here's the thing. I do feel like that happened. I don't know about the whole Mark, but I do feel like Mitch took the pictures and sent them like the first steps. Now, as far as murder sheets and Mark and how they got them, I have no idea. Maybe there was in between people and they just don't want to, get them in trouble or rat them out. But I feel like it did go to Mitch to Robert. I feel like that happened. Like, I really do feel like that is one of them. I feel like there was probably 2 leaks. I feel like Woodhouse got some information. I feel like even the state, you never know. In 7 years, they could have told one person could have, you know what I'm saying? There could have been little leaks that way, but I think the 2 main ones were Woodhouse and Mitch. I do think that Mitch and Robert, but here's the thing, I do think there's possibility that there's some people in between that we don't know of, and it might not be a direct contact from to Robert to Mark to murder sheets. Maybe that's what they're covering up. I just don't see what the point of Mitch risking that. But if you send me stuff, if you could find, information to back that up, or something that shows me like that leans towards that. Now besides the court TV, because I hear you said that they said December, but I still think that both could be true. You know what I'm saying? But yeah, let me know. Send me what you got. Hey, Hossein, what's up? I did too. Wait a minute, Hossein. We probably were thinking the same thing. When I read something different too on Souls. I'm sure it's the same thing, what we both did. That's so funny. I swear, I guarantee it's the same thing that we misread. Anyway, wait, he was being pressured by law enforcement and had other problems. They exploited him to set him up to defend with photos that they had a long time ago before Mrs. Wait, they exploited him to set up defense. Wait, who though? Wait, explain that. Who? Wait, they exploited him to set up defense with photos they had a long time ago. Wait, so you're saying this was a big plan to disqualify the defense? Is that what the theory is? That it goes that deep, like as far as that you're saying they had this Mitch guy lie about him getting it from Baldwin's house or Baldwin's office, so then they could end up like disqualifying them? Is that what you're saying? Am I? Oh no, that was in the text. David Erskine. Those were all over 3 years ago when I did that video. He said the same thing. Libby was no, so that was already out. That was something
that was
everybody
out from
knew.
people who already seen the crime scene.
Yeah, that was out.
Like in person.
But yeah, I didn't know that's what you were referring to. I thought you were saying they said December.
Yeah, that's what I thought too. The way you worded it, that's exactly the way it came off.
Besides that, hey, virtual reality, yeah, the whole thing that was definitely. And like also word of mouth, there's locals, the people that were at the crime. So not only David Erskine's text that we've known about for years, but also, like I said, people that were there that seen the crime scene, locals knew and talked about even what that Gertz got. You know what I'm saying? They hear things and they know, or the family member says something, or like locals that were there when they found him, they say David Erskine blabbed it all over. Other people probably told other people different details. You know what I'm saying? So that doesn't convince me. That gets passed around. But like I've said when I talked about Woodhouse, I do think that he has stuff. So December 2022, yes, I think things could have got out with him too, though. But as far as what you're saying with the girls, no, I don't think. I think, yeah, they knew that anyway. But I don't know here's the thing, I don't know if Woodhouse if he had those pictures and he leaked those too. But I do think Mitch did too. I think that whole scenario, maybe it's not exactly how they said it happened as far as like murder sheets saying the chain of people, how it worked. Maybe they are like hiding some people that were involved, but I do think it happened. I think Mitch was the first guy that went in there, and unless if you could show me or any other reason to think otherwise, because that doesn't convince me what you just said, because I knew that years ago too. Actually, I didn't even realize you were still here. That's good though.
Yeah, it said I'd be right back, and then but I'm still here.
But sweet dude, like here's the thing. What I'm saying is I do believe that that 2022 things could be leaked. I'm agreeing. I think it could have got out. Yeah. And I think that murder sheets could be hiding people. So I'm agreeing with most of you. I just do think that Mitch would too. And like I said, unless you could show me something else besides more than what you've said, then I'll look at it. Definitely. I'm open. But you haven't shown me anything right now to like convince me that the whole Mitch thing. I'm open to learning about it, but I'm not like convinced like, yep, that's set up. Like that's not enough for me to say that for sure yet. I get your theory. I just need to know. I need more information. Who released them? Who released them in 2022? Who are you trying to say released them? I don't understand what you're saying.
Yeah.
Yeah. Is there somebody specific? And who they release him to? Maybe they had him behind the scenes and gave him. I don't know. But I mean, I don't like. Here's the thing: I don't like saying something as fact, unless can we just say that's your opinion and that's one of your theories and you think that. But I don't think that's been established as a fact yet, right?
No.
But I know people just talk. I guess I'm more aware of making sure that I try to say what's fact and what's not because I'm a creator and I have my channel, so I got to remember like other people, that's just when you talk you just talk and you don't think you have to do that. But I just want to clarify that that's just a thing that you think's going on. But yeah, I'll look. Yeah, send me what you got. I'll check it out. I just think that there was possibly two different things going on, two different leaks. Now, as far as Mark and murder sheets, I believe that maybe they were lying who they got him from, but I don't see how Mitch. I feel like that's probably true because I don't see why somebody would take the blame.
Yeah, that's weird for him to fully take the blame like that, not knowing how he could be
Yes.
like
Oh,
charged or if at all or anything, I don't know.
And sweet dude, yes, it was known. Go watch my video from almost 4 years ago. I go over the text of David Erskine and finds him. Yes, it was known that one was clothed and one wasn't. That was a very known fact. Yes, 100%. I'm not lying. I've known it for years, and I wasn't even deep into that case. Like this case, this is the deepest I've got into it. Go watch. If you look at some of the cases I cover, this isn't one that I've covered as much as others, and I knew that. So yes, it was definitely I think most people knew that.
Yeah, I
knew it, right,
it all
Ashley?
until now, and I knew it too. So
yeah, it's definitely so. If that's why you're saying that, then no, I would dig a little deeper. Maybe you'll find more, but what I'm saying though, sweet dude, also, I do think that stuff was leaked in 2022 by Woodhouse, is what I'm saying. Because when I talked about Woodhouse, I believe that he has more than what they're saying. Oh, he just has an outline. No, I believe he's saying he got the whole discovery. I don't know how much he got, but I do believe that he's probably did have more than what maybe the defense is saying. I don't know. So I do believe that there could be another leak in 2022. And I do believe that maybe Murder Sheets maybe is hiding somebody too. But I just think there was two leaks.
Yeah, I agree.
And I think the leak of the girls, that was recent.
Yeah.
Now, I'm not saying there could be like people with inside sources that have seen them, but I'm talking about the main one where it was like more leaked. But like maybe somebody like trusted sources have seen them and relayed them. But as far as it getting out like this with media talking where they're actually talking about it, I think that was. But I'm saying I'm not saying that I don't think that there's possibility that Murder Sheets has had them for longer than what they've said. Yeah, that's a possibility. But I still do think that other leak happened for some reason. But not 100% that it happened in the chain of events like how they said it happened. But I do think Mitch was the guy that went to the office. I just don't know after that who they like the chain of what is the word I'm trying to think of? Chain of can't think of the word, but chain of there's a word I'm trying to think of how it like went down the line. I do think that people could have been involved in that and not, and they kept their name secret. But like I said, you could show me that it was somebody else, let me know. But not just the whole of known thing, because it was known. I swear to God. Watch my video from leaked texts. I think it was over 3 years ago. I did that, and people knew. There was people that said they knew about that like way before, and then locals talking about stuff that they know because they heard from other locals of people that were at the crime scene that knew David or Paul or not Paul. What's his name? The people that found them, they talk. It does spread. It just maybe it wasn't like.
All right.
People didn't like fully talk about it as far as not fully. Yeah, they did. Some channels would and some channels wouldn't talk about it. And that was one thing. I didn't know the rules. You know what I'm saying? So like, when I found those texts, because I wasn't like, there's some channels that just usually cover like one case and like their whole channel's like that case. And that's fine. But I wasn't like that. So when I came into Delphi, there was already those channels that were just like basically all Delphi.
Yeah.
So when I did that video with the text and to explain how one girl had the clothes and one didn't, a lot of people were like, it was new to some people, but the people that were heavily into it, they were like, yeah, we knew that. That was just something, we shouldn't share or something. I was like, well, I didn't know the rules. Like, I thought it was like, whoa, we all been wanting to know what the heck was the deal with this crime. Everybody's so hush hush, and so I didn't know. That was one thing. I didn't know the rules on that. But
yeah, why? Hold on, I do have a question. Why would that be something that you didn't want to know, though? Like, don't you want to know, like, the aspects of the case and the crime scene? Because I feel like even just that right there, that could maybe point more in the direction of like a sex offender, just because of the nudity and stuff. So like that could have, not that Richard Allen is one, but under other circumstances, that could point to a whole different suspect, that could give clues.
No, yeah. And actually somebody even wrote an article on my they included it in the article and like linked it of that video, and it was like, whoa, like people were interested, but the ones that were like diehard Delphi that knew because they were into it, they and I believe that they knew, but there was a like ton of people that didn't. So when I did that video, it got a ton of views because people didn't know about it because nobody was sharing it for some reason. And yeah, I thought it was important because we're all trying to figure out what the heck happened. And so to get a little bit of understanding, yeah, definitely. No, I thought it was important, and it was just that's what I'm saying. The Delphi community, now it's getting bigger because of everything going on, but back then it was like so like clicky.
It was so
it was
small.
like click like if you had to be like okayed by, well, we know the main guy that's like, if he doesn't agree with you, he's like the main, like he thinks he owns the case, but like he had to be like, you had to go by what they thought. And here's the thing. Oh, you've been trying to do it for years, guys. You can't figure it out. Isn't it good to have a fresh pair of eyes? Maybe you're not right because you're not. You know what I'm saying? So, like, they would be like, oh, if you don't go with what we think, we've been studying this for years. So, no, you're wrong. It's just like, what? I don't know. I did not like it. But it's different now because there's a ton more creators covering it. But back then, man, it was... Yeah, it was really bad. And like I said, True Crime Jesus was he was so awesome. Where is he at? He was the only one that like was so accepting and was so cool. But anyway, no, it can be, but that one especially because it was very like clicky, like it was just because those people were kind of doing it and they were
the Kylie Rodney case was clicky too. It reminded me a lot about that.
Really?
Yeah, like the clicks, like little clicky people, like, I don't know, certain creators would just go at each other,
Yeah, I had people coming at me for like from both sides. It was so weird. It was like, and then like, I heard that this is still going on. People accusing me for that whole thing where that Tyler got that video, and then I want to bring this. Well, I guess it's not going to get to the right people, but Tyler got that video from that one guy that he kind of went over my head and started talking to him. He got
Right.
that video, and then he said, "I'll share it with you if you promise not to." So I wasn't allowed to share it, but it didn't have anything on it. So this rumor with this one creator started this rumor that we had this video that showed Kylie or showed some information that we weren't sharing. It had nothing of importance on it at all.
What the heck?
But I would have shared, me, I would have shared it with everybody but he said, and one of the things, if I share with you, you can't share it with anybody. So I was like, shoot, that sucks. I'm not allowed to share it.
Right.
I wish I would have just said, screw it. Here it is. You guys are all coming at me for this. There you go. Do what you want with it. But
Right.
it wasn't anything. If it was, I would have showed the cops, or people were saying, oh, you're keeping this evidence for it's
Yeah,
you know what I'm
right.
saying? If it had something that was going to show what happened, of course I would have sent it to the cops, but it didn't. So why would
Of
I have turned it
course
to
you
the
would.
cops? It was nothing. It was very, like, half the time you couldn't even see what was going on. It was just like, what, you know what I'm saying? It was not
Yeah.
even important at all. So the thing is, but like I said, if I had got it, which I should have, because it was the guy I was supposed to, he wanted to talk to me, and then Tyler ended up reaching out to him before I was able to, and then he sent it to Tyler, and then Tyler had it and was like, oh, I'll share it with you, but you can't share it with anybody. So what would you have done? Somebody says, hey, if I share this with you, can't share it with anybody. Now I'm talking about if it didn't have anything of importance, wouldn't you just not go against what would you have done? Then just share, oh, I promised you that I
Yeah.
wouldn't, and then just go share it? Would you have done that?
Yeah, I mean, I might have. Yeah, just for transparency reasons. Yeah, maybe.
Oh, well, I guess maybe I should have, but it didn't have
But
anything.
I do keep my word to people though. So if I were to tell him that I wouldn't, I probably wouldn't.
Yeah,
But
because then
if I
it's
was
like,
going to, I would probably relay that anyway.
but that's
Yeah,
the
I don't know.
thing. Like, who else is gonna you're gonna swear and then you're just gonna do it?
Yeah, then
And
people
if
aren't
it
gonna
was just,
trust
it meant
you,
nothing, it wasn't gonna show it wasn't gonna prove or show anything. Like, what? I mean, what would be the point? I'm gonna break a promise for a
there's no
stupid
point
video
in it
that
then.
doesn't
Sorry, I
show
misunderstood you at first.
doesn't show anything. You know what I'm saying? Like,
Yeah, no.
like you're gonna break your trust for something that wasn't even important. Like,
Yeah,
to
that's
show.
stupid.
Yeah,
Oh.
but anyway, there's this creator that's still spreading it that, oh, I kept this information and this is big conspiracy. It's like, I'm about to just release it and then just be like, this is what you guys are like coming
Yeah,
at me
right.
for a
This
year.
is what you guys thought
For a
was
whole
so important.
year. You're talking so much crap about me, making it seem like I'm like this horrible person for this. Like, are you
Right.
kidding me?
For nothing.
Yeah. But I can't believe when somebody had contacted me and told me that they're still going on about that. I can't even believe it. Like,
Yeah, me either.
I even actually went on one of the channels that was bashing me. I went on and explained it all, but this girl is still spreading this crap. She's still trying to say that this thing happened in a way where it was Kylie or something, where I was keeping it and it was supposedly showed Kylie or something. No, it didn't show anything. So I don't know. It makes me mad thinking about it because this person was so, and I think she's the one that was. I don't even want to go on it. Yeah. So anyway. But then I got a lot of crap for continuing to just talk about the case. I got that, like, what's his name? Oh, the mom said quit and you keep talking. So I got crap about that. And then I got on the other side where I quit talking about it and they got mad. When I did quit, the people that were still wanting to talk about it thought that, you just fell for it. You just were manipulated by that video and so I got it from like all sides. It sucked so bad. I'm sorry, I'm rambling, but yeah, so why did I even bring that up? I don't even know.
Oh, it was my fault because I brought up how the Kylie Rodney case was always going after each other and stuff too.
Oh yeah, so no, you're right. It became like a lot of people started channels from that case.
Yeah.
There was a lot of new channels and yeah, no, I think it ended up turning into that. But I feel like when I was covering it, I didn't feel that way, but
Yeah,
I think it afterwards when people that continued, I think it started, but
Yeah, you were like one of the only people I watched cover that case, unless it was like breaking news. And just because I couldn't follow the hypocrisy from a lot of people and just the rudeness, like it was just a big cat fight. If I wanted to
Oh.
watch people fight, I'd watch wrestling or something.
See, I don't even know what you're talking about. Because like after I got out of it, I was out. But I imagine all those people that were continuing it, because it started getting that way when it was like after the
Yeah.
videos came out, the fire cam videos, all the
Yeah.
conspiracy, like all that crap started. But that's when I was just like, okay, I
All
felt
right.
like,
Well, I won't mention any creators. I'll tell you when we're not streaming. But
okay,
basically just like a few people were just like going at each other, talking about each other all the time. Like it was
oh,
a little redundant. I don't get how they were helping with that. And then, certain creators lying and on other creators and just lying even about the family and just a bunch of stuff. It was
oh, see,
crazy.
I don't know. I didn't know any of that. Okay,
Yeah, it got intense.
wow, dang it.
Yeah.
I
don't
just
blame
know,
me.
like, I
You
couldn't
stopped it.
win.
Like
I couldn't win.
I
If I
would've
continued to talk about it, I was getting crap for one side. And if I quit, I was getting it from the other. I was like, I can't even win. So I just had
No.
to back out. It was like causing too much stress. And I'm just like, but I also did feel like pretty convinced that I felt like, now seeing me, I did feel like she was lying. I don't know why. I do feel like something happened where they possibly something happened where she wasn't telling the truth about something. You know what I'm
Right.
saying? But I also felt like I didn't have anything more to offer. There's nothing more I could.
Right.
Uh,
Like
know
you
what
had
I'm
already said
saying?
everything you had to say like 10
I didn't have
times.
any more to find. And I also did find, I did feel like that those fire cams were legit. Now here's the thing. I feel like she did go in. I feel like she was in the water in the lake, but I feel like something happened before that Sammy was lying about. But
Yes,
how am I
agree.
gonna
I
prove?
agree.
You know what I'm saying? What am I gonna do? Like I couldn't, and I was getting so much crap for even talking about these kids, these high school kids. It's like, what
Yeah.
am I doing? Like you guys are like attacking me, so it's like, what? I can't do it anymore. If I dig deeper, it's like, oh my God, you're talking about kids. Oh, they're under 18, even though what's his name was 18.
Yeah, he
But I
was
got
18.
crap about that. He was 18, but I got crap about talking about him. It was just so ridiculous. It was like, God, I can't win. I just had to quit, you know?
With these cases though, I feel like to a certain level, ages don't really matter. Crime is crime, and you weren't like digging into them like just to be like a stalker. You were digging into them to try to help. Like I don't know, but some people were really like going too far with the family and stuff. I will say that much, but you definitely did not. You were sticking to the people who were talking, like like about who saw her before, and it's not like they didn't make themselves public. They were giving interviews. Like if they were trying to stay anonymous, I'd get it, but they were not.
Wait, who? Well, why can't I remember what his name is? What was his name? The boyfriend. Why can't I think of his name now?
Why can't I either now? Hold on, I'll find out.
Yeah, it was crazy. But I just hate how people quote that. Oh, when the whole autopsy thing, everybody's like, oh, what she did with Kylie. I'm like, what did I do? I didn't do anything. They bring that, oh, this isn't her first time, what she did with the Kylie case. What did I do with the Kylie case? Well, it depends on who you talk to. One group will be like, she gave up on her. She didn't keep looking. The other group would be like, she talked about the case when Kylie's mom didn't want her to talk about it anymore. That's the extent. And then the video, which was
His name was
nothing.
Jagger Westfall.
Jagger, yeah.
Yeah.
Yeah, it's just, oh, making me like, oh, thinking about it. Or because I had Ryan on, I disagreed with him when I disagreed with him. I didn't always agree with him. So,
I
you know what I'm
know.
saying? We just got along because we were able to talk like
Respect.
adults. And just because
Yeah.
I have somebody on, that means that I agree with everything. You know what I'm saying? It's like, why
Right.
can't we have guests on that we disagree with
You
and be able to
can.
still talk. And that's
You
what
don't
he
even have
did.
to have like
Yeah.
the person that you have
Yeah,
on.
you
Just-
don't. But I did like Ryan. But yeah, you don't like, even
But
if
you
I have
weren't,
somebody
like,
on, doesn't mean I
a
like
close
him. But I
friend, yeah.
actually did like him. I thought he's cool. But
Yeah.
it doesn't mean I agreed with him, and he knew I didn't agree with him. And the whole Kylie existing, I always disagreed with that. Of course she existed, and I never said she didn't. So that could be another thing people were saying. I don't know what I would like to ask people when they said that though. But it
Yeah,
sucks
me
because
too.
people that didn't know, they think then when people are like, oh, what she did with Kylie, now they think that I did something horrible with the Kylie case, when in reality I didn't.
You
Like, I want
didn't
you
do
to
anything.
tell me what I did with the Kylie case. That was
Yeah,
wrong.
please. Yeah, I'll see every once in a while just a random comment, like what she did with the Kylie case. And I'm like, what? What'd she
I know.
do?
It makes no sense.
You're not the one. I hate to put it in these words, but you're not the one the family's suing.
Yeah, because they would never be able to. I never once said
Yeah, you would be
anything
also
about her
sued
not
if you did
existing, because they're
something.
suing Ryan for the not existing thing, which I think it's like,
It's silly.
I do think that's silly, but I think he'll win. But
Yeah, I do too.
But like, no, I've never said that, and they would never be able to find me ever saying that. So yeah,
Right.
I
Not
actually went
expecting that
against
you even
it. Like,
tested that.
I like gathered as many, when Ryan said, "Oh, there's no pictures of her," I would go find as many pictures as I
did.
could of all ages and put tributes to show there's tons of pictures of her.
Yeah.
Oh lordy. Anyway, yeah. So let's talk about Delphi. So what about Delphi? I think I'm done, guys. I don't know.
Yeah.
I mean, as far as for tonight, I want to make
Right.
some clips from my live the other day. That I feel like that there were some important things that, since it's 6 hours, a lot of people were probably like, "Whoa, that's too much."
Right. I love how you're doing that. Like, you're taking lives and turning them to videos. I think that's so informative for people who don't or couldn't watch the whole live. It
Yeah,
pinpoints the
I
more
wish
important.
the last ones I did it, I spent like 2 nights staying up doing those, because
I
I'm
know.
so I need to stop doing that, because the whole point is it should be easy. But here's the
Yeah.
thing, like during a live, like, do I really want to release it when I'm like, let's say I'm reading a document, but then I talk in between, or but I need to, or there's like silence, or
Right.
I'm talking to the chat, I'll like cut all that out, but then it's taken me forever, so I need to just include it all, huh?
Right. Yeah, I would.
Yeah.
I will say they're good though. You can
I
definitely see
know,
your
but
hard
it's like
work.
they are, but it's just like it's taking
It's
forever.
too
So I need to.
much. Yeah,
If
you
the
gotta
whole
worry
point
about
is
your
just to
health
make
before
clips to
anything.
make it easy, like why am I need to spend that time on new stuff, like
Right. Yeah, you're right.
But anyway, yeah, dude, is dude still here? Dude, if you could send me stuff, but more than them just knowing, because like I said, we knew about that. But if there's more than that, let me know. I do believe there might be something not truthful as far as like how murder sheets is saying the chain of events happened. A lot of people do think that there's something missing or something there. Maybe they're just trying to like hide somebody's involvement in it, possibly. Or maybe they did know they got those before they saying. But I just need some kind of proof that with Mitch, that Mitch didn't do that.
Right.
I just don't get it. What would be the point? I guess, okay, either to frame the defense to get him disqualified, but I don't think that would be like have to involve, I don't know. I guess it could happen, but would that even be, I don't know. Would that be worth the risk of somebody, like
I
a
wouldn't
person,
think so.
yeah, like Mitch not talking, like, oh, Fran was involved. The judge would lose her job if she like, well, no, I guess not. Oh, no, not if they're all in on it. You know what I'm saying? If they're all part of it, I don't know. It's a lot to think of, but wait, Court TV guy video called judge issues gag order in Delphi murder case. If he's lying, he's good. Was called judge issues gag order in Delphi. Okay, so what? I'll watch it, but is it a new? You're saying it's from 2022? No, it has to be new because you're saying issue. Well, oh no, gag order, that was a while.
Oh yeah, true.
But as far as if you're just saying because they knew one was just and one's not, I'm just telling you that was common knowledge, just so you know. But I'll watch it, yeah, and see what I think.
Yeah, that was talked about far before anyone had ever
Before
Even
I even knew about it, people knew.
seen the
And I knew about
pictures,
it
yeah.
almost 4 years ago. So yeah.
Right, yeah.
Oh, thanks, blue-eyed bandits. Blue-eyed bandit.
Aw.
Is that your eye? Is that? It has to be your eye, probably, right? That's cool.
Yeah, pretty eye.
Oh, you know what? We could watch the court TV now. I do want to end this soon though, because I have that freaking dentist appointment too tomorrow, and I want to do a couple clips. But here, let's watch court TV. So hold on, I didn't even think about that. We could just watch it together. All right, hold on, sweet dude. So it's called Judge Issues Gag Order on Delphi. Well, is it? It's from this year, or what? You're saying that's from 2022? Judge Issues Gag Order. Hold on. Oh wait, I'm on the wrong one. Court. Hold on. TV. Oh, guess who's live on Court TV right now? Or it said live. Hold on, let me make sure. It says premiere. Yeah, it looks like it's right now. The murder sheets. So which one? Should we watch that or should we watch the one you're saying? What is it called? Judge Issues Gag Order? Is that what it was? Yeah, they're live right now with murder sheets. Okay. You're saying last year judge issues gag order. All right, let's watch it. Wait, that's 35 minutes. I don't know if I want to. I don't think I could do it in 35 minutes because, dang it, not right now normally. But dude, I just want to get. I gotta end this so I could get some stuff done before I.
Yeah, you have your early appointment.
Yeah. Shoot, sweet dude. I'll watch it though. I'll definitely watch it and then we could talk about it next time. Actually, this weekend I'm supposed to. You guys know Matt Sullivan.
Yeah.
Hopefully, we're planning to do live Saturday at 8. He's going to come on and we're going to talk. He knows a lot about this case because he's one of those ones that's like devoted, like that was his case. That's all he did for years. So he knows a lot. Oh, scroll to guy talking. All right, let me see. Well, there's a couple guys talk. Which one? He's got 3 people. They're reading the PCA. I don't know. Oh man, why don't I do it where I watch it and then I'll watch it like tomorrow while I'm waiting because they'll be making the crown and I have 2 hours where I have to wait. So I'll need to watch something. So let me just do that then and then we'll talk about it sometime when
I'll give you something to do.
Yeah, because I'm just tired. The first guy, yeah. I believe you, but it's definitely gonna clear up why if it's just something that was already known or not. But are you like not are you putting it out of the possibility that it was just Woodhouse's leak that possibly or no? And that there could be 2, or are you just convinced that there's no way it was just one leak and it wasn't this one? Is that what you're convinced of? Or you're not open to maybe there's a few different leaks? There's probably more than 2. I bet you there's a lot of little things where it's like, hey, I'll show you this. I feel like after 7 years, I bet you there's a lot of those. People trust, hey, I trust you, don't show anybody. To get their input, just like Baldwin was like, hey, I talked to Mitch to get his input on the case. Imagine before the gag order, because wasn't there a time, was there always hold on, I'm trying to think when it first, no, I guess there would be nobody that was, arrested, but people that were involved in the case. I don't know. I just think that there was probably little things here and there. Just like they actually were, we were reading in that document. It's impossible. You know? Because it's like, you know, think about it. You're like, oh, I trust this guy. I want to like talk it over. I know you're not supposed to, but we're humans. People do that. Like, you think about like sometimes you promise somebody, it's like, hey, I'm going to tell you something. What do you think of this? Because you almost have to share it with somebody. But you trust that person. And maybe 9 times out of the 10, that person does keep it. But you have those couple times where a couple people are, you know, maybe 2, let's say 8 out of 10 times. But you have the 2 out of 10 times of those people that you think. And they're doing the same thing. Well, I told this person because I could trust this person. I think it's happened because it's 7 years. Don't you, Ashley, or no? Do you think people really followed the rules and nobody said anything about anybody?
Usually.
And
I feel like people were keeping it hush-hush at first and to their belts, you know?
Yeah. Or locals that, you know, or the family tells somebody that they know something, or locals that were there. It spreads. There's just little things that people know, you know, that more than the public knows. And then I want to know what Woodhouse got.
Yeah, me too.
Is it as much as he says, or you guys aren't convinced? You guys think it's just like, it really is just like an outline of.
I think it could be.
I think it's more, but I don't know. I guess he could just be saying that to, you know, look cool, not look cool, but make it seem like, oh, I know more. But I don't know.
Right.
If it was just an out, I mean, why would it, like an outline?
I don't know, maybe, but I think it was a little bit more than.
I know, I'm thinking too, but when that live when I played it, everybody's like, he's lying. It's just a thumb. I don't know. Somebody said thumbnail. Somebody said nothing. I forget what other people said, but they made it think it was like just like nothing important. But I don't know.
Well, they already released the photo, so that alone was important. But yeah, I think he's got more probably, or had more.
Oh,
I doubt he does now. He probably made sure to delete all that crap.
No, but that's the whole thing. They told him to delete it, and he wouldn't. And then they arrested. He went to court, and he's in jail now. But
you're right.
And he thinks it's like this thing where they're doing it because he does know the information, and that's what I'm saying. So we are agreeing.
Yeah,
so
we are.
So you think it's Woodhouse? Sweet dude, this whole thing, and we're saying the same thing. We're coming to the same conclusion. Of course, yeah. I do think that he has some. I've said that since the last week when I did that live. Yeah, I think. Okay, so why are we even debating? I think we think the same thing, basically.
Yeah.
Besides, I do think Mitch did. I think there's 2. I think both of them happened, to be honest, though.
Yeah, I do too.
He offered video footage then. Or maybe you're not even. Wait, maybe I'm misunderstanding you. Maybe you're not even talking about Woodhouse. I don't know. Who freaking knows?
Yeah.
But how do we know that the email that you guys have seen, that it's not? How do we know that's everything? You know what I'm saying?
That's true. Yeah.
Like, you might have seen like screenshots of it, but how do you know that there's not more to it, though? Process how he of new names, and Baldwin process how he defend. Okay, the first Baldwin link, the email is out there. It's a table of contents with lots of new names. And Baldwin's process how he dissects. I don't know, Blue Eyed. No, I don't think there's more. I think that the bullet's gonna be their main thing, and then him admitting to being there, maybe wearing the same stuff as BG, but I don't know, and I'm afraid that there's not, because that's the thing. If there's not, it's one of 2 things: that Richard really was involved, and they're not gonna have enough to convict him, or he really wasn't, and there's a possibility of them convicting him, and is he innocent, and he could be innocent. I don't know. I'm afraid that no. If I were to guess now, I would say no. I don't think. But I hope I'm wrong.
Yeah.
Well, I don't know though. Maybe not because if there, because what if there is and then it's not? What if it is like planted stuff or something and then he is innocent? I don't know. I'm still open to the fact that he could be involved in some way, but I think it's not just like him going, him saying down the hill and then him killing the girls. If he's involved, I think there's more people involved.
I do too. Yep, that's my exact thought. I've always thought that maybe there were two people to begin with, like a couple of guys, but like I don't know. For a while, I lost that theory. After I learned that Abby and Libby, they would not have left each other in that circumstance. They would have tried to help each other no matter what, like sisters would kind of. But I don't know. Right now, I still think it's possible there were more than one people. I'm back to that theory.
Yeah, me too. Especially because the whole here the DNA thing. So this was a screenshot. So I don't know if this is true. This was on Reddit, so take it for how you want. But this says Riley would not provide a specific timestamp for the picture or say how the image had been captured due to the ongoing investigation. Riley said that the investigators had cleared a number of people who were in the Delphi historic trails at the same time as the girls on Monday. At the moment, we've talked to everybody that we feel that has been through there, and none of them are coming up as a suspect. He added, everybody is still a suspect, but this isn't the right one. Hold on, I'm reading the wrong one. I was like, wait, this doesn't sound like the one I wanted to read. Hold on a second. Whoa, I don't even know what that was. Hold on.
Something I would do.
Oh my god. Okay, this is the one I wanted to do. Okay, so this is Fred. It says the following is a list of unofficial, unverified rumors told by someone I trust. Nothing here is official and should be considered only a possibility and not a fact. Over the years, I have had discussions with hundreds of people on the topic of Libby and Abby's murder, from YouTube content creators to actual detectives working in this case. The individual who provided me this information is under a gag order, so I will not entertain any questions about their identity. DNA collection was difficult due to the large amount of blood belonging to both Abby and Libby. Only a partial DNA sample has been collected. The partial DNA sample was used to exclude multiple individuals as early as summer 2017, including Ron and the Kleins. Both Kleins. Alan does match the partial DNA sample. Alan's daughter and her husband are listed as witnesses for the state against Alan. Alan made incriminating statements to his son-in-law prior to his arrest. His son-in-law and daughter went to the police shortly afterwards, ultimately leading to the arrest of Alan. Murder weapon was a Bowie knife. Neither victim was SA'd. Law enforcement believe an encounter just before the Monon High Bridge led to Alan's actions, and the killings were not premeditated. I don't know how much of this is true. I do trust the individual who told me, and I do know the majority of this information is already known by those who follow this case obsessively, so I'm sharing it with you all. Again, none of this information is verified, so it should be considered a rumor. But yeah, I thought it was interesting. So
Wow.
it didn't exclude them, but it was just the sample is contaminated basically, right? So I guess they don't have enough. It's a partial DNA. So they can't say for sure, it looks like, but it didn't exclude them. But they were able to exclude that rumor, the Kleins and Ron Logan. So I wonder if Patrick Westphal, how they took his DNA, were they able to exclude him? So they can't confirm 100% if this is true, but they can exclude, I guess. I don't know whether that's true or not, but that's that. I thought that was kind of interesting.
Yeah, that's very interesting.
Is there anything? Let me see what else I had for this one. Oh yeah, this was like all the like names for the Anthony shots. So a lot of people think that like there are a lot of fake accounts that Keegan made up. And look at all the Vincent's ones. Vince. What's this? Oh, yeah, I already read that. Oh, that's first to talk about something else. Yeah, so yeah, I don't know. That's about it. But yeah, the first link. Okay, yeah, I could buy there's more than one link. That's what I've been saying.
Yeah, you've been saying
dude.
there's a couple.
I've been saying, yeah, I believe that there's more than one leak, but I do believe the Mitch one happened too.
Yeah, me too.
But the people have been talking about how what murder she's saying, like how it got passed on, that there's something not that fishy about that. But I haven't looked into that real deep yet. But there's people have been saying that from day one since they came out that something's going on that they don't believe totally. Something. If they're hiding something, but I never heard that Mitch is, I mean, maybe, but the whole Mitch thing is completely, I just thought that they were just trying to like protect somebody else and they didn't want to give all the names up,
Yeah.
but who knows?
My whole thing is I keep wondering if maybe there's a set of crime scene photos, like, you know, with the markers, with like the little yellow markers and stuff. And then, which I'm sure there are, because usually there are. And if maybe there's another set of photos that were like trophy photos from the murderer.
So one of them, you're saying something got leaked before from, wait, explain that.
Not necessarily a leak, but I'm just wondering if like the person who did it took photos.
And they have it? Are you saying it's in the discovery?
No, not that they do. I'm just wondering if they did. I don't know.
Possibly, but
yeah.
Yeah, there's always a possibility.
Like I almost wonder if these photos were like that I've seen are the ones that there are ones that were maybe trophy photos, because they don't look like official crime scene photos. I don't know. I just can't wrap my head around how those are official crime scene photos.
But if Baldwin is admitting that that's where the leak came from, is his office, then that means they would have them. That means the state. Those would be the ones in the discovery. So if they got them from somewhere else, then wouldn't they know where they got them from? Or maybe where would they have got them from? But I agree they don't look official. But
I mean, who knows? I don't know about that for sure.
Unless if they do it, they did get them off of Richard's phone, and they
see. That's what I'm wondering. I'm wondering if maybe that's the like nail in the coffin thing with him. It wasn't the bullet at all. Maybe that's. Yeah, maybe they got them from Richard's phone or computer or something. You know, that would just be crazy.
Dude, that's huge.
That would be a definite guilty right there. If that were to come out that he had photos of the whole crime scene and everything, that would be nuts.
But how would so maybe it's like the defense is trying to put that seed of doubt because they know they don't stand a chance once that gets out. But
photos, then, he might have had them or whatever.
But wait a minute. Why would they take that case on pro bono and put everything into it if they know that it's worthless if they have that?
Yeah,
I don't
right,
see
though.
that.
That's true.
I don't see that.
That's true. I wasn't thinking about that. So yeah, maybe just like, I don't know. Maybe just like, maybe it wasn't Richard, but maybe just somebody took, them as trophy photos and they got in the hands of somebody or something. I don't know for sure. I've just been thinking about that since I saw them myself, because I was like, yeah, they kind of don't look official.
So wait, sweet, you do that? Wait, we just went on for an hour of this whole other thing,
yeah,
and then it just comes back down to like exactly what I was saying. I'm so confused. Now I feel like everybody else was. Hopefully everybody else wasn't like, "What is she talking about? Why are you?"
No, I knew what you were talking about. I was confused about what
shit for even like talking about this other scenario with Sweet Dude for so long. But that's fine. No, because there are a lot of people that I've heard that they are suspicious of what murder sheets. They're not. They're like thinking there's something missing. So yeah, there is something to that maybe. But as far as like maybe there's somebody missing in that chain.
Yeah, I don't know why people,
But I don't know why I don't know what the reasoning why people are thinking that though. You know what I'm saying? Like, is there like some kind of fact where they're like, well, wait, because of this?
Yeah, I know.
I
That's
don't know.
what I
Who
know
freaking
too.
knows? But yeah, let's get off that subject for now. I'll watch the
Yeah.
court TV, but I feel like yeah. Because now that you're back to, yeah, I do think Mitch, wait, so Robert or Mark took photos of Mitch's photos. Yeah, I mean, definitely could. I mean, isn't that how they said it happened, basically, anyway? The more you know. What is that? I don't even know what that is. I'm sorry, guys. I feel
Oh,
like,
the more
God,
you
that
know
last
thing. I
What
know
is
what they're
it?
talking about. It's like that rainbow picture that has the rainbow and it says the more you know in it.
Wait, Petty, isn't that what we just read this whole live? I think I read all that already.
I think it was, yeah.
Yeah, that was the whole point of this. That's why I did this live, is to read those actually. Um, all right, I think I'm gonna go because I was gonna just like make my pre-records, but I saw those new files, and so I was like, I'm gonna hop on a live and read them. But yeah, that's what we did. All right.
All right, I'm off.
All right, Ashley. Thanks.
Thank you. Thank you for having me.
Thanks for coming.
You're welcome. Bye, girl.
Bye.
Bye, chat.
Right, bye. Oh, I see. I was thinking you were saying Zav read some. You're saying Zav reads. My God. I'm sorry. You guys, I wish I could just erase this last hour of this live because I feel like it's just been bad. Oh my God. That was a blonde moment of mine. Oh my God. Wait, you're not a what? Wait, I feel bad. You're not a something, definitely not. Not a bro. Oh. um. Yeah. All right, guys. Yeah, so Saturday, I think we're gonna do the thing with Matt, which will be good. And then, oh wait, Ashley, are you still here? We should schedule something for the Adnan. We should just like I should just get something on the books, like to have it, so then I have to go through it. It sucks because I have such a busy week too. I gotta do the dentist tomorrow. I have to do then I have to go to my lawyers for something, and then I have to go to my INR and get these EKG records from my other clinic Thursday, which you know how that is, going to the hospital trying to get records. It's nothing is that easy. You know, it's not just like you go in and get them. It's like fill out this paperwork, wait here, do this, go there, fax that. Ugh. And then Friday and then Saturday that. I don't know. When do you want to do it? I definitely want to. Maybe Friday? I don't know. I took yesterday. I just like because you know with this depression, I'm having an off day. So yesterday was my day. I just was like sleeping all day, and um, so I haven't got to dig anymore into Delphi. So I still want to do that too, so I could give some new stuff. I feel like if you didn't see my 6 hour live, I feel like I went over a lot of stuff. You should check it out. I should probably get some timestamps, but I am going to try to do clips of it. But I thought it was pretty. I went over a ton of stuff, but yeah, I don't know. I should just say a day, but I'm scared to commit because it's like I have all this other stuff to do. It's like, but we have to do it soon because everybody's watching it. By the time I do it, everybody's gonna be past it. I have everybody start watching it weeks ago, and then it's gonna be like you're gonna be on to something else. Um, All right, I'm gonna go, guys. Bye.